Hi, everyone. Welcome. My name is Lacey Meeks, and this is Criminally Confident. I'm so happy that you have decided to spend some time with us today. I know you could be just about anywhere else, but you've chosen to spend some time with me, and I'm super grateful. If you're watching live, make sure to say what's up in the chat. And if you're watching on Restream, please let me know in the comments. It helps the algorithm tremendously, as well as hitting that thumbs up button and making sure that you're subscribed. So as long as we have covered all those bases, let's get into the meat and potatoes. Today we are covering the third day of the Afroman trial. It happens to be taking place in the same state as I reside in Ohio. I'm about 90 minutes away, and it has been absolutely crazy. It has been um shocking, to say the least, and I felt absolutely obligated to share this with you, and I hope that you are able to ask yourselves some really important questions in the chat, including but not limited to the repercussions of what this lawsuit has on not just Afroman, but Americans as a whole in our First Amendment. Does this work to create a slippery, sliding slope of protected peoples? Does this protect groups from ridicule and parody? Or are the police right about this? I want to know what you guys think. And I really appreciate you engaging with the chat and letting me know those things. Let me go ahead and say hey to some of the people that are in here. What's up, y'all? Shout out to my mods. Hey. Thanks so much for helping out today. Hey, Willa. Thanks for being here. Hey, Kimberly. What's up? Paul said he watched the Afroman diss tracks. Yeah, they were something. They were something. Kristen, how are you? Thank you so much for helping out today. Stan's a member. If you are enjoying the content, you can always become a member, by the way. And it starts at 79. Starts at $7.99 a month. If it was $79 a month, I would be set. So, oh, as a virulent racist, I'm firmly on Afroman's side. Okay, that's a lot. I saw that you saw that. Yes, I know you felt very strongly for Corey. Oh, it happens. Accidents happen. Thankfully, Willa is super chill and he knows that we weren't conspiring to kick him out of the chat. Okay, guys. So I already have the video queued up and ready to go. And I'll be coming in here and there to present questions, but I also have a poll that you can take. And I have also pinned a comment for you guys to read. So make sure to take a look at those. And thank you again for being here. Once again, I feel like I have to tell you guys this because of people that weren't here yesterday. There were some words about the videographer in this situation. There's only one, and I don't know what's going on, but he's just been either coming in late or just not turning on the camera in time. This is Afroman's ex-wife, and this is the defense presenting their first witness. So in case there was any confusion about this, because I was confused when I watched it today.
You've worked with kids for how long?
30 years.
You got into the mind of kids pretty well.
Yes.
When they would play Mr. Foreman's song Lemon Pound Cake, did they take that as a literal fact from your observations?
No.
Were they laughing and joking about it?
Oh, yeah. Absolutely.
Are you familiar with the song WAP?
I think I've heard
Sorry,
it.
no, strike that. I'm going to give you the complete song and then summarize it because I only want to say it once. Are you familiar with the song Wet Ass Pussy?
Yes,
Is that a rap song?
it is.
Has your students played it in class?
Once, and I asked them to please turn it off.
When they were listening to it, did they think that was fact?
No,
So they didn't think that that was depicting anything in real life?
no,
So you didn't have to teach them that wasn't real?
right. No, I did not.
You've heard the song, correct?
Mm-hmm. Yes.
Do you believe it's a literal interpretation?
No,
Would you agree it's derogatory towards women,
no.
even though it says nasty things about them?
Yeah, no. I mean, it's
Actually,
the artist's opinion, I guess. That's the way I feel.
just so you guys know, there are 2 streams going today. We talked about this yesterday, and I had a discussion with my assistant, and she recommended that we do 2 streams. So if you want to watch on a computer, you have that option. If you want to watch on your phone, you also have that option. Thanks.
Maybe not an opinion you like, but
Yeah.
Your Honor, if I may have one.
Go ahead.
Yeah, no problem.
So, Ms. Grooms, has Mr. Foreman's posts about Sean or any of the general posts about the Adams County Sheriff's Department as a whole affected your life any at all?
No,
Would you believe it would have affected your life while you were married to Sean?
if it had any effect, I guess that would be the time it would have an effect.
Wait.
But as his spouse, you would have expected it.
Yes.
Okay. And I don't want you to go into too many details, but is it fair to say that Mr. Foreman, the posts about the police department, everything had not a damn thing to do with your relationship between you and Sean and why it came to an end?
No, it did not.
So the posts never affected your life, never affected your marriage.
No.
Okay. So any statement to the contrary would be false?
Yes.
Okay.
So this isn't his life.
Thank you very much. No further questions at this time, Your Honor.
Cross examination.
Thank you.
Morning, Ms. Grooms.
Good morning.
I'm sorry you have to be here.
I am too.
Thanks for coming. Where to start?
Where did it go?
You never sought a protective order against your ex-husband, did you?
Yes, I did when we divorced. The divorce. Yes, I
Did
had a
you?
restraining order.
You got a restraining order?
Yes, I did.
Were you aware of the posts that were coming out after 2022 about the sheriff's deputies and calling them thieves and that sort of thing? Did you ever see any or hear any of the songs?
Some of my students referred to it and they would say, I saw your husband in the video. And I would say, yeah, that was him, and turn around and walk away. I
Okay.
didn't elaborate on any of that, no. And
What?
they didn't either,
Why didn't you elaborate on
because I didn't think it was the student's business.
it? Okay, so they had seen your husband in videos,
Yes,
and did you tell your husband about that?
about,
That your kids had mentioned it?
No, it was just a mention and that was it.
Okay. And did you ever, you saw the posts yourselves or videos yourself, or did you just hear about it from kids?
I saw part of it and then I heard about it.
Okay.
This is the problem with the videographer not
And
coming in on time. I
Did
really
anyone
thought
else in
that
the
was
community ever say anything
Afroman's
to you
ex-wife.
about these videos or posts?
No.
Just your kids,
It's my students in the school.
students? Okay.
That's crazy. So they got one of the plaintiff's exes. Oh my God, that's like salacious.
The song that Mr. Osborne asked you about, does that song refer to a specific identifiable person?
I don't think so.
Those are all my questions. Thank you, ma'am.
That is awkward. Wow.
Rhonda,
Rhonda.
Mr. Klingler asked you about your students. Your students saw the post
Yes.
and they articulated it to you?
Yeah. Just say, hey, I saw your husband in this video.
Students can, would it be a fair statement to say children can be mean? Cruel?
Absolutely.
You've seen instances of them being cruel?
Absolutely.
Are they cruel to both other students and teachers?
Yes.
Breach.
I don't like bringing up sensitive subjects, but has any of your students ever been cruel to you in the past?
Oh, yes, definitely.
Would it be fair to say they've said some pretty mean things?
Yes.
You see, I'm trying not to ask you what they are, but are they shocking names?
Coming from my students, I mean,
I just had
in
to
all
ask if
honesty,
there were
it's, you know,
sirens going
when they're mad at me because they didn't receive an A,
on here.
yeah, they get mad.
And they
And-
lash out.
Yes.
But they're not calling names a fact or anything. to us.
No.
And they've seen these posts.
Yes.
Did your students treat you any differently?
No.
So could you point to any instance where a student treated you differently due to the posts?
No.
I'm going to ask this question. You said you're sorry to be here. Why are you sorry to be here?
Because
Oh,
from
she's
my
shaky.
recollection, my ex-husband had said that this was part of the reason we got divorced.
No further questions, John.
Mr. Klingler? No further questions. Mr. Osborne, am I right to understand this witness was a lay witness?
Pardon me?
This was a lay witness, not an expert, right?
Duh.
She's a lay witness to testify to what she would have experienced in this.
And the only reason I did that is to explain to the jury that people sometimes have training experience and can make opinions as experts. Dr. Something.
I wonder which plaintiff Sean is, because I can't help but wonder if that's the lady that that got in trouble. If you guys recall yesterday's stream.
In a medical malpractice case, they're an expert. This is a lay person, the same as any other. Some of the questions spoke generally about society and public perception, which would seem like more of an expert opinion, when in fact, as a lay witness, she can only testify about what she experienced herself. So you have to understand the scope. She's just what happened to her, lay average person, not educated expert. Thanks for being here. You can be excused. Go ahead, Mr. Osborne.
Your Honor, I'd ask for a short 10-minute break so I can talk with Mr. Foreman. Based upon the ruling in the Rule 50, I want to juggle some of my witnesses, make some corrections to that, as I had anticipated a different verdict due to the evidence, or different ruling due to the evidence, so I'm going to need to shift for that. I'd like 10 minutes to consult with my client to strategize on that.
Comments, Mr. Flanagan?
No, I have no objection to that, Judge.
You're doing well managing your time. I think that's a good idea. I would like, how I did with getting the jury on schedule.
Your Honor, that's why I want to strategize, see how we can hopefully.
Yeah, well, I appreciate what you're saying. Take a break, go back to the jury room, stay there if you would please. Short break will be helpful.
Okay.
Joe, follow me up, please.
Back from the break.
No rebuttal, Judge, no further witnesses.
Okay, thank you. So, ladies and gentlemen, we're moving forward to the point where you get the case handed to you. What comes next is closing arguments and instructions of law. So closing arguments are meant to be the opportunity for the lawyers to tell you what they think the evidence means. If you want to take notes, do so, but like draw a line on your paper and say argument, not fact. I don't know how you keep notes.
All right,
I
now.
have to keep them
I was trying
organized
something. Sorry.
so I can realize who's talking. You've seen me do it a couple of times. Lawyers aren't evidence. The witnesses are. It's the same thing here. I don't think you would get confused or misunderstood. The plaintiff goes first because the burden of proof is on the plaintiff. The plaintiff also, because of that burden of proof, gets a privilege. So they get not only the first word, but they get the last word. So Mr. Klingler would start, Mr. Osborne would go second, and then Mr. Klingler would get the last word.
We're going to
Not
speed
because
this
of
up.
favoritism or anything else, but because of the burden of proof. At that particular point in time, we'll give you jury instructions. And I'm going to take a break after their arguments because I need to make a few copies for the lawyers to read while I read. We give the instructions to you in writing, but I always like when they can read over my shoulder because sometimes I put two words in different order and change the meaning. So then we have like three people
That's a problem, sir.
to make sure it comes out to you right. So we'll hear their closing arguments, take a short break, we'll get the instructions, and then we'll turn you loose. Go ahead, Mr. Klingler.
Your Honor, if I may, procedurally, I'd like to renew my motion for the record.
Thank you. Very appropriate. With regard to the false light claims, the court overrules the motion. Outside the Presbyterian, I can give you a little bit more of the why. But when I give deference to the evidence, it's strict favor,
Welcome.
especially with regard
And
to highly offensive and reasonable juror,
essentially, yes.
reasonable public perception. Like those clearly become fact issues to weigh, which I shouldn't do. So as a matter of law, I couldn't dismiss the claims. There's at least enough evidence when I construe the plaintiff's evidence in their favor to get past the Rule 50 motion. But you are spot on to remind me to do that.
Your Honor, there's also another matter we need to clean up. We probably should do at the sidebar before we go into oral arguments.
Okay. I like cleaning things up.
Willa. Look at that American hero. And someone pointed something out on X this morning, which I have taken notice of, which is that suit is epic. That suit is stitched and sewn and put together like a true piece of art. I don't know. Maybe that's the guy, his ex-wife. I don't know. I'm just making assumptions at this point. We should probably figure that out. Okay, so we're at 27:45, 27:28. They're talking, and they're about to switch over. I love the America suit as well. Hi, Michaela. Welcome.
By a vote of 3-0.
Please make sure you guys to hit the thumbs up button and sub up.
Because often they use the instructions in their argument. So like the chicken scratching stuff that we've been doing in the past is distracting. So we're going to let me do my work. It's 30 minutes that we need. So we'll go take a coffee break and stay back there. Instead of me doing it the other way, we'll just take the break now for the jury instructions.
Can't smoke any smoke.
The bailiff doesn't like irritable
They want a
jurors,
smoke break.
so you should go smoke.
So
Do you like irritable jurors?
I prefer not to have.
Okay, yeah, go take a break.
Right.
I was actually watching voir dire this morning and like jury selection, and I can't show it. I don't have the person's permission, but it's someone who lives down there who attended. And interestingly enough, I'm not shocked. There was not a single African American on the jury panel, like the group of potential jurors that we saw. Now, from my time in Adams County and doing campaign stuff around there, I mean, that is a very, very white place. There aren't a lot of people who are African American. I don't necessarily think it was like an intentional jab at Afroman. If we want to call a spade, like I really don't think it was. I just don't know if the people were there, and if so, if they had a pre-existing relationship with that family, then that they wouldn't be allowed to be jurors anyways. So I noticed that, and then I noticed that the judge was like trying to keep this lady on to be a juror while her father-in-law was dying. And she was like, I'm not going to be able to focus. And he was like, well, oh my gosh. And he was like, well, this is your civic duty. And finally, like, the defense was like, please let her leave. We don't want her to be stuck here if she cannot be here. So she left, and I wish her nothing but the best in case she is watching. I don't know any other Ohio creators that are covering this. So not that you have to be from here, but it adds a nice, like, in my opinion, a nice perspective to know the area, to know kind of some of the stuff that goes on. All right. Has anyone seen the lemon pound cake video? It's hilarious. I have. And yesterday I was showing the testimony from the first 2 days, but I had to skip through all of the parts with the songs because they're copywritten, and I get a copyright strike against me, which basically means I can't, if someone wants to advertise with me, I can't make money from it. I can't, it doesn't make sense for me to do that. So I was trying to, oh, probably why it was going so slow. That's why I was working the computer super fast. I muted this, so it's going because it's about to start from where I have this set. Yeah. Let me keep my finger on the unmute button.
To the jury whether the five plaintiffs are private figures or public figures, because the right decided that. So in the instructions, I've taken prior decisions of law where necessary and put them in. And you didn't deal with that. But sometimes I have to tell the jury how we got to where we are. That becomes instructional law. The law of the case goes into the instructions. So I don't explain it. I'm just saying in the record, I took prior judicial law of the case findings and slotted it in where necessary. That's what we always do. Sound right, Mr. Osborne?
You're all right, no, Judge. No objection, Judge.
Okay.
Yes.
Off the record. Mind, I'm sorry.
Your Honor,
Yes, sir. We're on the record.
well, we have the two housekeeping things. I renew my verdict, and then we have to also discuss the music company.
Okay. All right. Okay, so 2 points came up. You review your motion for Rule 50 the
Yes.
dismissal. Mr. Court overrule. Mr. Klingler responded to your inquiry about media access incorporated.
Yes, Your Honor, just for the sake of the record, we had a telephone conference on this. We had discussed this issue. They had not they were technically in default of the answer during that telephone conference, which was not on the record. We discussed what would happen with that. Mr. Klingler said he would evaluate it. We are now about ready to do closing statements. No evidence has been presented against him. Mr. Klingler has not asked for a default judgment. He seems to be wanting to put everything on my client, which is very strange. Why, when he has a default, he wants to make a motion for such. But we would ask that the record be cleaned up in that issue.
Yeah, I'm going to clean up the record and we are going to dismiss that party from the case.
Media access incorporated.
Yes.
We registered an objection to him not doing a directed verdict, or sorry, doing a default verdict on that, and therefore increasing damages upon my client if they should be found.
No, that he gets his own complaint, so I just have to follow his lead, but I get what you're saying.
But I can argue for mitigation of attorney fees and stuff that he has done.
Oh, you can see that. That's not part of the cruise.
I just have, I'm trying to think a step ahead.
I like that. On the record, please. Go ahead and do it, Mr. Taylor.
It was extremely uncomfortable how much the judge was advocating for the plaintiff in this situation.
See, I knew that. I waited the extra 30 seconds.
Again? No. I'm so cold. I always forget to turn up the heat before I sit down.
Okay, thank you, ladies and gentlemen, for your patience. Have a seat. Actually, it's about 45 minutes, so I didn't gauge my time very well, but thank you for your patience. We are moving ahead, as you know, so most people don't growl about that, but I try to at least respect your time and tell you what we're doing. We made it through like the corrections to the jury instructions. Like I've been trying to educate you all the way through. The jury instructions are the
Hey,
textbook,
Mod,
yeah.
any
Chance to,
Jules, please let
throw
me
those
know.
down. As I said before, closing arguments are the attorneys'
Thank you.
argument about what they think the evidence means and how you should do whatever it is they think you should do. So they go first, Mr. Klingler, then Mr. Osborne, then Mr. Klingler. It was like a total of 35 minutes. So I'm going to take 20, 35, 15. But Mr. Klingler can kind of manipulate his time depending on how he wants to do it. So in an hour, you'll be talking to me for about 30 minutes of instructions before you start your deliberations. That's what's ahead of you. If you take notes, just write down argument, not evidence. Go ahead, Mr. Klingler.
Thank you, Your Honor.
Yet I didn't expect anything different. This is why it's so difficult for me to commentate.
Morning, folks. When this trial started, I told you it was about intentional lies that are designed to hurt people. It's not about freedom of speech. It's about defamation. It's about false light defamation, intentional lies designed to hurt people. You've heard all the evidence. You've seen the witnesses. I'm not going to go over it, but I will say a few things to underscore what I think is most important for you to keep in mind as this case is turned over to you, from me, from the plaintiffs to you. Mr. Foreman perpetuated lies intentionally, repeatedly, over 3.5 years on the internet about these 7 brave deputy sheriffs who've lived in this county for years, risked their lives for this county for years, done their job, been in the community for many, many years. Mr. Foreman did it intentionally. Mr. Foreman knew that what he posted on the internet were lies. He knew there was no theft. He knew there was no sex with Randy Walter's wife. And he certainly knew all of the stuff he's repeatedly posted about Lisa Phillips up until Friday and probably later were lies too. What are we going to do about that? Mr. Foreman told you from the witness stand, there's nothing we can do to stop him because he has freedom of speech to lie about people intentionally. During jury selection, we talked about that. And you all agreed that it's not okay to tell an intentional lie about someone that hurts them. We all agreed. And the judge is going to tell you that in the law that he gives you. So Mr. Foreman is legally wrong when he says he has free speech to tell harmful lies about people and get away with it. That's just legally wrong. You also told me in jury selection that even if somebody does something to you that hurts you, that you think is wrong, like a search warrant execution that you think was unfair, even if somebody does that to you, you told me, we all agreed that that doesn't justify telling intentional lies designed to hurt people. That's what you think. That's what the community thinks. That's what decent people think. But Mr. Foreman thinks it's okay to do what he's done over 3.5 years because they executed a search warrant that broke down his door and disconnected his cameras. You heard from the witness stand from Mr. Foreman the callous indifference that he showed to what he's done, the harm he's done. It's imprinted in your minds, I'm sure, like it is in mine. The tears, the agony from some of these witnesses, don't forget that when you're back in the jury room. That's what this case is about.
Is it? I hate that they only need
You are
6
here
people to win
because you agreed to be
on
here.
an 8-person trial.
You showed up
Jury.
on the first day. Not everybody does. A lot of people don't
Isn't
respond
that
to their
against the
summons.
law?
You did. I asked you, do you want to be on this jury? And you all said, yes, I agreed to be on this jury. You're all here now, in this place, in this courtroom, for a reason. And I believe there's a power higher than us that brought you here today to do this job, and that you are the chosen people to do it. Nobody else is going to do it. There's not going to be another trial. There's not going to be a second chance. This is the day to decide whether Mr. Foreman gets away with what he's done and whether these plaintiffs deserve something to make up for what they've been through, and whether the community is told that what he did is unacceptable. It's not okay. We talked about different kinds of damages. There's not going to be economic damages in this case. There's no doctor bills. There's no damaged property. There's damage to reputation. There's pain and suffering. There's public humiliation. There's everything you saw and heard.
Is that what you guys are
from
hearing?
these detectives from the witness stand. And the only thing you can do as a jury to decide this case is to render a verdict of money that somehow stands in, somehow represents the harm that these deputy sheriffs have been put through over 3.5 years. That's all you can do. You can't.
What about protection? If they're scared, what about things other than monetary relief?
Can't issue an order that says stop. You can't issue an order that says, say you're sorry. All you can do is issue a verdict for an amount that fairly stands in, represents what they've been through, what they've lost. No one else is going to do it. The judge isn't going to do it. Court of Appeals isn't going to do it. It's your job. And you're the people meant to do it. Now, I told you in jury selection, if we got to this point, I'd try to give you some ideas about how to evaluate
Miffed.
what kind of verdict might make sense in this case. I told you then, and I'll tell you now, there's no formula. There's no easy answer, but there is an answer. And it's the answer that you folks decide among yourselves fairly represents the injuries that these deputies have suffered. And I'll start by posing this question. Do you think that if there had been an advertisement in some newspaper that said,
The petty level.
we will give you $2 million if you are willing to go through what Lisa Phillips has been through for the last 3.5 years? Would you take that deal? Do you think she would have taken that deal? Yeah, $2 million, that's maybe I'll go through that. Of course not.
Might not.
Do you think Randy Walters? Do you think
He's for a new home somewhere
Ryan Newman?
else.
Do you think any of these deputies would have accepted some amount of money in order to go through, in exchange for going through what they've been through? I don't think so. And I think you know nothing is worth going through what they've been through. And of course, he says he's not going to stop. He says nothing can stop it.
Oh my God. What happens if
Maybe something can
these
stop him
people lose?
if you tell him through your verdict that he needs to stop.
I know. I know.
I'm going to tell you what I believe is a fair verdict for these plaintiffs.
Oh my gosh.
And it's up to you, of course, again, to make the decision. But I would ask you, I'm going to ask you, and there's a verdict form, which, excuse me 1 minute.
Frenchie. My 14-year-old dog is humping my girl.
Folks, I'm going to
Frenchie.
show you these forms that
I
you're
believe
going
he
to
can still
be
do
filling
that.
out, just so you're familiar with them. This is just an example. You're going to have a different form for each of these plaintiffs. Okay, this one happens to be a verdict form for Lisa Phillips.
Thought I was going to
And-
sneeze.
I believe the evidence is overwhelming that you'll find in favor of Lisa Phillips. This happens to be her false light claim. There's a separate claim for defamation, a separate form for defamation, and you'll see the jury instructions. Judge Hine has already talked some about that with you. So this is just an example of the verdict form that I'm going to ask you all to sign in favor of Lisa Phillips and all of the plaintiffs on their false light and their defamation claims. Now, there's another form called an interrogatory. And again, I'm just showing you Lisa Phillips's form. And it says, we, the jury, find damages for plaintiff as follows. And then it gives a little description of the kind of damages. And there's a line for your decision, and
You
there's
can go
signature
back
lines for each of you to sign.
And watch my stream
For
yesterday.
Lisa Phillips. I'm not going to show you every form.
Good.
For Lisa Phillips, folks, I'm asking you to put $1.5 million in that verdict form. $1.5 million for Lisa Phillips from what she's been through for 3.5 years, maybe going through for who knows how long.
Just a reminder, guys, please make sure to hit the like
For Brian
button
Newland,
and to subscribe.
I'm asking you to issue a verdict for $1 million for what he's been through with his family, the loss of his dream job here in Adams County. For Randy Walters, I'm asking you for a verdict of $1 million for what he's been through with the allegations and vile videos about his wife. For the other 4 plaintiffs, Sean Grooms, Sean Cooley, Justin Cooley, and Mike Estep, I'm asking you for a total for all 4 of them of $400,000 divided among them however you see fit based on their testimony.
There were a lot of things that I feel like the defense didn't touch on. And, you know, I hate to Monday morning
You, of course,
quarterback.
can award less. You
But-
can issue a verdict for more. That's what I'm
a very
asking
good
you
point.
to say in your verdict form based on this testimony. Now, let me close my remarks by looking into the future here and looking at the future if there's a verdict for the plaintiffs and you award the plaintiffs a fair
Mitchell.
amount of money.
All right, let's
What
go ahead
happens?
and do a membership giveaway.
The plaintiffs are vindicated. The court of public opinion out there, the press, which I know you haven't been looking at,
Okay, go ahead.
they don't know the facts. You know the facts. And the verdict for the plaintiff will say they were wronged, he was wrong. A verdict for the plaintiffs
This way.
will make up in some way for what they've been through. A verdict for the plaintiffs will say that we don't condone, we don't approve. You can't get away with what Mr. Foreman's done. Not in this community, Not in this country. That's not freedom of speech where we live.
All right,
That's what a
guys.
verdict for the plaintiffs.
Make sure
We'll
that
say.
you have liked this stream and
Let's look at
commented,
another possible
and we'll
future
do a
if there were
giveaway.
to be a verdict for the
5
defendant,
minutes.
or if there were to be a verdict with a small amount of money attached to it. In that case, in that world, in that future, the world is told what he did is okay. What they went through is no big deal. We don't really care. We think it's fine. That's what a verdict for the defendant or a small verdict would say. They would go home subject to even more ridicule. Yeah, you took him on and you lost. See what he did was fine. I don't have to tell you, that's not the message we want to send. It's not the message you want to send. Folks, I'm done. I've done all I can. These folks called me 3 years ago now and asked, what can we do to stop this? And here we are today. I've done what I can. They've done what they can. They've suffered through the publicity. They could have stopped this case at any time if they would have kowtowed to the pressure, public humiliation that Mr. Foreman continued to put them through, but they didn't. They bravely stood behind their case and their right not to be drugged through the mud with lies in the media. They've done all they can. And now I am giving their case and this decision to you.
I think we're
It's out of my
picking up
hands.
some viewers from Ricada's
You have to
chat.
decide.
Hello, everyone.
What to say to Mr. Foreman and what to say to the community about what he's done and the effects that it's had on these folks. I have full confidence. I fully trust you to make the right decision, to make a fair decision, and to come back with a verdict that's fair for each one of these plaintiffs and that tells the community what you really think about this case.
Hi,
Thank you
Josh.
very much.
Thank you, Mr. President.
I get so excited when I see Josh. That means I'm doing something right. Rare to have a lot of my mods in here. I'm so excited. Thank you, guys.
Ladies and gentlemen, thank you for being here. This has been a long 3 days. It took a second for me to even count the number. It's been so long. A lot's happened. You've done your duty as jurors. You've paid attention to the evidence. I'm proud of that. What makes our country great is you have the right to have a jury trial. You have the right to people in the community to see this, weigh the evidence, and make a decision. And I'm proud that you guys are here and doing that. We started this time, I talked about this case was about freedom of speech. But let's talk about what it's also about. It's also about music. Not all music is tasteful. Not everybody likes all music. There's some songs I hate. I think we can find plenty of people that find songs they do not like. But Mr. Foreman, Joe, is a rapper and comedian.
You're welcome.
That's what he's done his whole life is rap, make
I'm
songs.
Trying to give away
You gotta think of what
memberships.
rap is, because music does not exist in a vacuum. Music evolves over time. Take a look at jazz. It's evolved. At one time, it was distinct in a certain subculture, and it has now expanded. Rap is the same. Rap started out as a means for people to express social commentary, opinions through entertainment. Look at the song by NWA,
I don't think they
What they
know
call-
that song, hon.
Fuck the Police. I think I said that right. It's a social commentary on what was going on in their lives, their personal effect, the personal things happening to them, combined with entertainment, which unfortunately is exaggeration,
All right. Should we do it? Giveaway?
opinion, nothing of fact in that song. It's a commentary on society.
Let me try one more time.
And so when you look at rap, you see that over and over again. I had my secretary
go.
print me a couple songs, rap songs, while I was pouring a cup of coffee. And the first one is Carly B, WAP. I find it bad to say what WAP means, but it's a popular song. I think it's somewhat derogatory. But then again, I'm not the audience for that song. And I know that. I know nothing in that song. Nothing. Talking about,
Congratulations.
I know it's entertainment. I know it's social commentary. Miss Grooms testified even her students knew that at a young age. The same thing I knew when I was watching Johnny Carson, The Late Night Show, and SNL, Saturday Night Live, with my grandfather when I was a kid. That's all entertainment. They make fun of everybody for entertainment. And some of it is a social commentary. But it is not fact. And everybody knows that. Nobody looks at Lil Wayne's song Pussy Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. but it's not fact.
Oh,
And I can
I'm so
keep
happy
going.
you
Megan Thee
got
Stallion,
it.
sex talk.
You're welcome.
I mean, it just goes on. They use derogatory language. It's designed to entertain. Drew Hastings, former mayor of Hillsborough,
Thank
was a
you
comedian.
so much, Stan.
I got to go to one of his stand-ups. Some of it was
Make
funny.
sure to say
Some of it
thank
wasn't.
you to
Some of it was
Stan if you
jokes,
got a
like those
membership.
of Eddie Murphy and Richard Pryor. Some of them are not tasteful, but they're still jokes. They're not facts. And we know that. That's what a reasonable person listening to that would understand. And that's the point. This is not a vacuum. We don't live in a vacuum. Let's face it, if we lived in a vacuum, we'd all be dead because we couldn't breathe. So we live in a world full of everything where we see things. We watch SNL. We know it's entertainment. We know it's going to pick on people. We understand that they're picking on public officials. They picked on Joe. They pick on Donald Trump all the time, Sleepy Joe. I mean, go down the list, even Teflon Ron was made fun of. So as you go back, nobody thinks that's fact. Nobody's going to take it that way. When they post their clips on YouTube, when they post their clips on Facebook, people don't look at it and go, that's the truth. No, they understand it's comedy. They understand they're going to talk about it going forward. And if you look at his posts, you see the little signs of that too. Iteration. Things that you see in a song. I mean, because after all, you know, a song's catchy, right? It has beat, song, you know, words rhyme. You know, she thinks the tractor's sexy and, you know, sticks with you. When we listen to Lemon Pound Cake, you heard the iteration. You heard how it came together as entertainment. So we don't exist in a vacuum, and a reasonable person doesn't exist in a vacuum. As the judge said, you are a reasonable people. You get to decide what's reasonable, which means you get to use your experience. You get to use your understanding of what those are, of your understanding of Joe, of your understanding of rap music, music in general. I'm not going to sit here and say that these 7 people were happy about what happened to them. I'm not going to say that. That'd be
No.
stupid. But what I am going to say is they are public officials. We see it on the news all the time. Public officials make fun of them. Let's go back to voir dire. During my voir dire, we talked about, with the one juror who's gone, we talked about that, yes, I ran for public office. She agreed I put myself out as a public official. She agreed that it was an opinion when someone called me a baby killer. Even our witnesses
I
on the
need
stand.
to
I asked that
know
question.
more about that.
They said a crooked defense attorney is not a vine. It's a matter of opinion. Crooked cops, dirty defense attorneys. Oh, wait, one witness did want to say I might not have taken a shower. But those are all opinions, exaggerations, not statements of fact. And we know that. And that's why public officials are held to a higher standard, because that standard is what is expected of them as subjecting themselves to public scrutiny. They all testified that people have criticized their work. I mean, after all, we look at the search. There is, even Mr. Newman admitted it wasn't perfect. I think we can see from how the money was handled, the investigation. I would have liked to have seen a more thorough job myself. I mean, we have the chain of custody, the money that just leaves it laying there. Mr. Newman didn't know that. We have an unsealed evidence bag. We have 10% of all evidence, money evidence in the Adams County evidence locker miscounted. And then keep in mind that miscount on those is less than what is alleged in this here. We've got people saying we had a miscount, yet they can't even bother to notify the court in an official document that they made a mistake. Just let it ride. As far as the public record knows, which they never corrected, Mr. Foreman never got back all this money. They want to talk about an investigation, but they can't even put in a single piece of paper to correct his mistake. I don't know if I call that lazy or what, but I think it goes to what you consider a fact. Because what is a fact? We can't always know what a fact is. Fact is something you can disprove, right? But can we truly disprove it? Looking at all the evidence, there is questions. If there's questions, it's not a fact. Now, people will form opinions based on that. I formed an opinion. I imagine everybody here's formed an opinion. We know that they formed an opinion because they didn't like being called a thief. So that was their opinion. But people are allowed to have opinions. People are allowed to express them. What people are expressing when they call them thief is not a literal statement. It is not a fact. It is a social commentary on the fact that they didn't do things correctly. And they can't even articulate how they could fix it. That is a social commentary if I ever heard one.
His yelling is so
They don't like it? That's not their choice to like it or not. They're public officials. They're going to be held to higher standard. Their work's going to be criticized. I mean, that's just what happens when you're a public official. No reasonable person would expect a police officer not to be criticized. They've all been called names before. Has it affected them personally? Yes. Ms. Grooms testified it made no difference in her life. Her kids didn't take it seriously. And she's taught for damn near 30 years. But they seem to take it seriously. And I come back to Mr. Grooms. He's worried about going out on a call and being shot. Now, maybe I'm old-fashioned. But if I'm going out on a call, I'm worried about getting shot. I'm going to call my wife and tell her to be safe. Not sit here and go, I'm worried about me. That's not
Sir,
what you do. You take care of your family. Mr. Walters one point.
why are you yelling?
That just goes to show us he didn't take it seriously. Now, I'm not going to say they're not afraid. Anytime they go on a call, the highway patrol will tell you scariest thing's a traffic stop. You know nothing about the person. You're there by yourself, and things can change in an instant. Is that scary? Fuck yeah. I'd be scared. But if you're truly scared, you take the steps for it. You start having your family do stuff. You start doing that. If
Thank you again,
believe what you're saying, you
Stan.
take the steps towards it. You didn't take steps. No one else talked about how they took steps either, did they? And why does that matter? Because a reasonable person is going to look at that. After all, let's go back to me not taking a shower. How would you know I didn't take a shower? Hair crumpy, matted, I got dirt all over me. That's how you would see. That's how.
Out of all the metaphors and examples and relatable analogies to give the jury, was it the smartest to pick one about him not showering? Come on.
You would prove if that's an opinion or fact. Now, even then, you might say they just fell in the mud. But no reasonable person would take it in the vacuum. And I want you to think about everything in context. What rap is music, how it's entertainment, how the language works on it, how jokes are made. I want you to think back to that because that colors how you see it. I love picking on Joe. He's a good sport for it. Look at that suit. Does this look like a man who thinks that everybody's going to assume that everything he's saying is fact? I mean, he's like a comedian. He exaggerates for the sake of entertainment. That's who he is.
That's one way to put it.
To everyone, but some people do find it entertaining. I asked an important question about them. I said, do you believe everything in the newspaper? No. Do you believe everything you read on the internet? No. We all know that to be true. A reasonable person knows that. People can post opinions, social commentary, and hurtful things all over the internet. And it is just to be expected. That's why we are supposed to use our own filter, use our common sense, use our experiences in life. So while hurtful, it was not fact. It was music, entertainment. Stuff that no reasonable person would understand, especially not a public official, because we see it on TV all the time. We see it on the internet. You see it on Facebook. Sometimes people want to turn off Facebook because there's so much political commentary and stuff.
I don't look at
But that's
Facebook
expected.
anymore.
Do I expect everything I read is fact? I don't think most of it's fact.
I just fight
I
on
think it's everybody's
Twitter.
opinion, and opinions are like assholes. Everybody has one that stinks. But that doesn't mean they can't have it. That doesn't mean they can't express them. That doesn't mean they can't make a song about it. Truth is a defense. That's why we talk about theft. That's why we showed all that.
Give me one
Because I
second.
wanted to see how the money was handled. There's a lot of confusion around it. And for that reason. Before I get to another point, I want to address something that's bouncing around my head. Bob says, what does this message send if you find for Mr. Foreman? I rephrase that question a little differently. What does this message send if we find that music and social commentary, while maybe not the most tasteful thing in the world, is silenced because a public official, while hurt by it, yes, unhappy by it, yes,
I agree.
pissed off, yes, emotional, yes. What opinion does that say? I mean, if you can sue people, music artists, comedians to shut them down, that's what we're looking at here. I'm sorry they feel the way they do. But there's a certain amount that you have to take as a public official. It's part of the duties as a job. As we talked about during voir dire, as I talked about them being called a baby killer, there are certain things you take and you move on. It's part of the job.
But why are they calling you a baby killer, sir? That's what I'm concerned about.
Plaintiffs, or I should say Bob talks about how they wanted to stop. Where was the certified cease and desist letter? Where was all this done? None of that was done until after they started the lawsuit, until after they brought it to court to make it stop. That's what they wanted to. They wanted to make it stop. Yet they asked for money. The commentary on them is nebulous at best. You can see that when you look at it. We have Beetle Bailey, Gomer Pyle, Colonel King Kong Bundy. Some of these names are not as bad as others, yes, but they're all for artistic purpose. They're all for jokes. They're all for entertainment. This is not paint them in a real life. No reasonable person would think that. It's kind of interesting because even Mr. Newman agreed that he was called a pedophile by Mr. Foreman. Yes, that is a horrible thing to call a person. But even he said it was Mr. Foreman's opinion. So he didn't believe it was a fact. If your own witness doesn't believe it's a fact, how can a reasonable person find it's a fact? Bob went to great lengths to say nothing will stop him. Shows us where we're at. We got to stop his expression. We got to stop entertainment. We got to stop exaggeration. That's what Bob's talking about. What chilling effect does that have on the world we live in? Think about it. You don't like what a commissioner does. You don't like what our prosecutor does. You don't like what any public official does, and you make a joke, and you're drugging the court. It may not have been a tasteful joke. It may have been a bad joke. It may have been the greatest joke ever. But what we're saying is if they don't like it, we're back here. What does that say to you? Freedom of speech. What does that say to the world we live in?
I had to turn on
That's what this case is about.
space heater.
And
Sorry.
Bob knows that. That's why he mentions it. That's why when you look at defamation in the jury instructions, you'll see that the first element of it is a statement. Portrayal of fact. Has to be portrayed as fact. No music video portrayed as a fact. I don't watch Fuck Those Police and turn around and say, you know what, that's a fact. No. I say that's a song, it's entertainment, and move on.
Yeah.
Sometimes I try to figure out what the words mean, what kind they're getting at, but I don't expect them to present fact.
Most of us are
Fourth
trying
element
to
is
figure out what the
approximate
words
cause.
are.
It's an interesting question there because you'll get the definition of causation and approximate. And we never talked about that really during the trial. It's going to be something that I want to discuss. They talked about getting phone calls. None of those posts. Joe never said, call them and tell them this. Mr. Cooley testified that they mailed pound cakes to the office. Joe never said send them a lemon pound cake. These are things that other people have done. Joe never directed them to do it. He didn't cause it. He made a joke. He cannot control how people take it. What they do, he's not that. All he can do is make a joke, make a song. So that's something to consider. Was he the proximate cause or was it someone else? I want you to understand when they get to the question of malice, if you get that far, it has to be actual malice. Public officials, it's a higher standard. Why? Because we hold public officials to a high standard.
I don't think they would have
Let's
eaten
talk
the
about
pound
false light.
cakes.
That's their second cause of action. That says that a reasonable person would be justified in the eyes of the community
I don't
for
know.
feeling seriously offended and aggrieved. I want you to go in on the eyes of the community. They want to say people's humiliating them, calling them names. The reality is a reasonable person in the eyes of the community is going to say, it's a song. It's a joke. I was flabbergasted to hear it myself that they even thought it was a joke before they brought the lawsuit. Go to a Halloween party and bring a lemon pound cake. That, I almost have no words for that, honestly.
Yeah.
I get, we're hurt, but it's a joke.
This is
what we're
where
trying
my mind goes.
So a reasonable person in the eyes of the community would understand it's a joke. Mr. Eastet testified about
Y'all, when I decided to leave lobbying and try teaching, I taught in a extreme emotionally disturbed room for 6th through 8th grade, and we had like 8 students, and they weren't allowed out like with the rest of the school. And when they brought us food, we immediately had to throw it away.
joke of the shirt. We got the pound cake joke. There's various jokes for this. This was not as negative. This has not changed their view in the eyes of the community because your reputation, which is what they claim is hurt, your reputation is like a shirt. You eat a hot dog, you drop mustard on it, you get stains on your shirt. Nobody's reputation is clean. Everything you do affects your reputation. The way you perform your job affects your reputation. They all admitted to that on the stand because I asked that question. They all said it does. How they counted that money affects their reputation. People can form opinions based on how they did their job and criticize them on it. That's a right we have.
I love that you're here. Hello,
After getting
my
I
love.
flip through these, we didn't have a lot of time to prepare as things change on the fly. I think as you go back and deliberate, take a look at all these issues, analyze it in the context of music, entertainment,
old do you think
opinion,
he is?
social commentary. It's not fact. And if you look at it, you can see that. Like I said, it may not be tasteful, may not be nice, but even SNL is not nice. South Park's not nice. These things are social commentaries, jokes, entertainment, and some of them are not nice. But you don't have to like everything. You don't have to like everything said about you, and you don't have the right to tell everybody that everything said about you should be sued for, especially if you're a public official. As such, I ask you to deliver a verdict in Joe's favor on all claims. I ask that because when you look at it, no reasonable person could see it as a fact. No reasonable person could see it as even false light. The community, if people called them, that's because the social commentary resonated with someone, resonated with what people experienced in the world. We've lived through a turbulent year, so we've all seen on the news what people are experiencing all over the country. Social commentary resonates because of that.
Yeah.
That doesn't make him the proximate cause. That shows a deeper concern in our country that we should be addressing, not sitting here trying to decide if a music video is a factor.
Yes, Dan, I could
That's
see
what's at
that.
issue here. And I'm confident as you go back in deliberations, you'll come to that conclusion too. And with that, I thank you again for your service because it is not easy. And what you're about to do is not easy. It takes time and deliberation. It takes hard work. And I appreciate that you guys are willing to do it. And I reiterate again, that's what makes us a great country. Thank you very much.
Go ahead. please.
Thank you, Ron.
And if you are unfamiliar
Nothing
with,
Mr. Osborne said about sexually explicit songs out in society refer to
just gonna give you guys like a heads up. If trials aren't normally your thing and you're just tuning in because of the celebrity factor of this, with it being Afroman, the way that it works is that the plaintiffs go, then the defendant, and then the plaintiffs get to rebut everything that the defense said, which is mind blowing, but that's what he's doing back up right now.
specific people in the community, like the songs that are at issue here. It's not the same thing. We all know that. These weren't opinions.
Wow.
Mr. Foreman didn't say, in my opinion, Brian Newland is a pedophile. In my opinion, they're all thieves. In my opinion, I fucked his wife doggy style. He said it like they were facts. And I think Judge Hine is going to instruct you, based on everything that's happened so far, that these were not opinions, they were stated as fact. And your job is to decide whether those facts were true or not. And we know they're not. The case isn't about lemon pound cake. It's about intentional lies designed to hurt people, and they hurt people. If somebody in the jury room says, well, what about his First Amendment rights? You know, and the law tells you, that doesn't allow lies that hurt people. If someone tells you it's just artistic expression, he ought to be free to say what he wants, the answer is he's not allowed to wrap up harmful lies into songs, so-called art, put them out there and get away with it. The packaging of the lie doesn't make it okay. The message was clear. And Mr. Foreman doesn't get to wrap himself in the American flag and say, you can't touch me. I can say what I want, no matter how untrue it is, no matter how much pain it causes people, no matter for how long, because
that's his next song.
Speech. He can't do that. I'm confident you'll tell him he can't do that. Thank you.
Let me acknowledge the Mr. Osborne.
Your Honor, I didn't mean to interrupt you. My thing is, I was going to ask Cory to read the jury instructions if I could use the restroom break for that.
I think this
Everybody's gonna stand in the-
attorney needs his
Everybody's gonna leave the room, but you-
prostate checked. I'm sorry to go there, but this attorney has had to like leave 3 times to go use the restroom, and I'm worried about him. Someone needs to like check in with him and make sure that he's taking care of himself. Right, I fast forwarded. There we go.
Often the lawyers start with the jury instructions when the case comes in the door. Then the court refines the instructions to account for the conduct of the trial. So to the extent that they might have gotten the instructions very quickly this morning, it's not that they didn't know it, it's the refinements, the little tweaks along the way. That's what they're talking about. But I want to thank them because they did good work, making it possible for me to get to the point where I can give these instructions to you. The court has a legal duty to prepare the instructions of law. You've heard the attorney's statements, arguments, you've heard the evidence from the witnesses. The court's duty is to instruct you on the law. And then you have a legal obligation to accept the instructions
He doesn't look
the way they're
that
given to you.
much
It's your
older
sworn
than
duty
me,
to do
though.
that. You cannot apply what you think the law ought to be. You're obedient, as I am obedient, to the rules of the law. A person who claims that certain facts exist, in this case, the plaintiffs have to prove them, in this case, by what's called the preponderance of the evidence. You've heard me say this before. I'm going to try to go over things you know, but the obligation is called the burden of proof. Plaintiffs have to prove those facts by a preponderance of the evidence. Preponderance is more evidence in favor of their position than opposed to their position, tilting the scales in their favor. There's one element that has a different burden of proof. Clear and convincing evidence, a higher amount, a greater weight of evidence has to be proven with regard to the knowledge or the motive for publishing.
This is
I
interesting.
generally think, okay, can the plaintiff prove their case by slightly more evidence in their favor than evidence opposed to them? There are 2 claims, what we've called defamation, and secondly, false light invasion of privacy. In your deliberations, each of those claims is deliberated separately because there's separate rules for each. I'll give you more, but there's separate law for each of those separate claims. There's 7 plaintiffs, each of whom is entitled to their own deliberation. So when I refer to plaintiff or plaintiffs, what I'm saying to you is that side of the room, but you always have to apply these facts individually and separately deliberate each person's claims. If you rule in favor of one plaintiff, it doesn't mean you have to rule for all the rest of them. If you rule against one plaintiff, it doesn't mean you have to rule against all of them. So it's not like an all or nothing verdict. It's 7 deliberations. And I'll use plaintiff and plaintiffs interchangeably, just understand the analysis and what I'm trying to communicate to you. So to go back to burden of proof, preponderance is the greater weight of the evidence that you believe outweighs or is overbalanced by the evidence opposed to it. A preponderance of the evidence is evidence which is more probative, more probable, more persuasive. It has greater evidence value to you. Look at the quality of the evidence, not simply the quantity.
Stop
If it
scaring
was only
me.
about quantity, there would be more plaintiff witnesses than defendant witnesses. So you think, oh, just because of the number of witnesses, someone must prevail, when in fact you look at the quality of the evidence. Don't get hung up on which side called the witnesses. Think about the quality of the testimony, what you took from it, regardless of numbers, regardless of where it came from. If it would turn out in your mind that there's an equal balancing, the evidence opposed to it in favor are equal, then the plaintiffs have not met their burden of proof because they didn't tip the scale slightly in their favor. If you could decide a fact or an item in 2 different ways, you have to decide it based upon the facts, not guesswork or coin flips, or I don't care. So in those areas where it's hard or it's difficult to resolve, you have to resolve it. You can't leave it up to, I don't care, and I'll just flip a coin or it doesn't matter. Guesswork's not what you're expected to do. The heavy work of sorting out the facts and deciding which side of the scale they go on is the role of the jury. Now, when we talk about preponderance, slightly shifting, we also have to talk about clear and convincing evidence, a different standard for that one element of motive to publish. Clear and convincing evidence is a higher or greater amount of evidence. You have to be more convinced. Clear and convincing means the evidence produces in your mind a firm belief or a firm conviction that that item is true. So preponderance might be, by example, slightly tipping the scales. Firmly convinced is more convinced, greater evidence offered by the plaintiffs with regard to the motive or the
Wow,
knowledge
Stan, that's
of
interesting.
publication. What's the evidence in trial? Evidence is testimony and exhibits. Evidence is direct and circumstantial. People scratch their heads on this, but it makes sense later. Direct evidence is when a witness has an opportunity to see or hear those things about which they testify. I sat here, I watched the jury take their notebooks and write in their notebooks. Direct evidence, an eyewitness. Circumstantial evidence is different. Circumstantial evidence is when you look at the facts and circumstances surrounding something you saw, and then you make a conclusion that something else actually occurred. I saw the jury box empty, I saw the pencils, I saw the notebooks, I saw the end of the day, the notebooks were all open, there were words written there. So it's circumstantial evidence that the jury took notes. I didn't see you take notes. But from the facts and circumstances that I did see, it's a reasonable conclusion of fact that you did take notes. Why do I tell you that? Most evidence came at you both directly and circumstantially. Things that I personally saw, and then things that happened as a result of what I saw. Circumstantial evidence is fair game as much as direct evidence. Direct evidence isn't better. You might think it's better when in fact it's not always better, because the witness didn't tell you that they were blind when you thought they saw something, or it was foggy, or the lights were bad. So when you think about the evidence and how to weigh the quality of it,
Thank you for
what a person
subscribing.
saw, what they heard, what the person experienced is good evidence, direct evidence. But so is the circumstances around that testimony. They're both fair game. Often people infer that something exists based upon the circumstances and inferences. I inferred it's a reasonable circumstantial evidence that you wrote in your notebooks. That's fair. But I'm not allowed to infer because you took notes, therefore you also did something else. You can't stack an inference that something else occurred on top of something else you thought occurred, on top of something else that could have occurred. The idea here is what we call remoteness. It gets more and more unreliable the more remote you get from the first circumstantial evidence. If you want to say the circumstantial evidence is reliable, great. If you want to infer that that's reasonable, great. But don't stack another, oh, now I suppose something else happened. And if that happened, then something else should have happened. It's stacking, it's called remoteness. Then it gets unreliable. With regard to the exhibits, you saw exhibits, there was testimony related to them. Consider whether the exhibits are in fact what they're portrayed to be. You decide what weight, if any, the exhibits have to have when thinking about the testimony involving them. Exhibits in video can speak themselves, but sometimes paper and other exhibits don't. So you have to consider what the witness said in light of how the exhibit was portrayed. Don't make inferences or conclusions based upon the number of exhibits. Remember, I want you to look at the quality, not just simply the number. Like theoretically, the plaintiffs had more number of exhibits than the defendant. Don't care, don't count numbers. Look at the quality, make the content important. You'll have like physical, tangible paper exhibits back there. When you get to the video or the data-driven exhibits, you'll have a computer back there so you can use that to look at the exhibits. So it never works that way. So I always offer the bailiff services that he can come back and, as you saw, make the technology work. So if you struggle
My
back there
bones
with plugging
cracking
in thumb
again.
drive and finding the drive and then turning it on, we would expect that. I'll tell you how to communicate with us, but just ask for help. We'll send back a very capable bailiff and they'll save the day. Evidence is not what the lawyers say. You heard opening statements, closing arguments. That's not evidence. It's helpful, it's necessary, it's built into the system, but it's not evidence. If a statement was asked and the question was not answered, there's no evidence from the question. I did that once or twice to show you how it works. Just, you might have thought the answer was going to be yes because the witness was shaking their head yes. The witness was, yeah, I understand the question, and the answer is no. So you can't use body language to get an answer that wasn't spoken from the record. I don't think that happened too often. But remember where the evidence is. It's the exhibits and the witness statements, not the lawyering side of the case. There was times where I sustained objections and handled the lawyers the way I thought was necessary. I always ask people to apologize or accept my apology if you thought how I handled the lawyers was any kind of a comment upon the quality of the case. Like, I try not to do that. But you might misunderstand that in scolding a witness or handling a lawyer, I was expressing an opinion. I love it when you guys show up because I don't have to decide. It's like I always try to make sure I'm neutral in my facial expressions and my voice tone, but sometimes I just don't get that done. An important role for the jurors is to weigh credibility. Credibility is assigning believability.
I don't even know what to say to that.
To the evidence, assigning weight to witness testimony, assigning weight to the exhibits. When you weigh evidence, you're basically deciding truthfulness. And as odd as it sounds, it's what we do all the time. We weigh credibility continuously each day. In weighing credibility, you should look at, consider the appearance of the witness on the stand. Consider the manner in which they testified. Did it seem straightforward? Did it seem honest? Did it seem evasive? What did it seem to you? So you're using your eyes and you're using ears to weigh credibility. Think about how reasonable their testimony was in light of the subject matter of the trial. Consider education, interest, bias. Consider if they were frank with you or not. We use these tests every day to decide whether we want to rely upon or find a person believable or not. As I told you before, every witness took an oath to be honest in their testimony. The oath does not bind you that just because they're talking, I have to believe it. In fact, you have to parse it out because people could very honestly get up and say, I believe this to be true, when in fact they're misunderstood and wrong, not lying. So recognize you can parse the evidence. You can believe everything a witness said. You can believe nothing a witness said. You can pull out the pieces you think are credible and ignore those that you think are not credible. And then you shuffle that entire deck with every witness along the way. As a rule, we want people only to testify, general rule, about things they heard and experienced and saw, firsthand testimony. So that's the general rule. But then we violate that general rule because we let people express their opinions about what the facts or circumstances mean that they experienced. So in deciding what their opinion means and how you weigh their opinion, you do the same thing. You're allowed to hear their opinion. It's evidence. But you have to, again, parse it out in terms of the credibility test. A person can give you an opinion, and you might go, I don't believe that because that's not in their subject matter, or they don't have enough knowledge, or their emotions get the better of them, or they have an interest or bias or whatever. And you might go, no, it's a completely valid opinion because of whatever credibility factors you have. So we give you direct testimony, we give you circumstantial, we give you opinions, and then tell you to weigh out those things you find believable, credible, and otherwise.
That's a scary false read.
In this process, the jury sits around as a committee. And it might be that you find a person credible, the other person finds somewhat credible, and the other person finds not credible. Expect that to happen. And then resolve those differences back there. There's more about that later, but in this whole deliberation process, that's normal. Somebody said while they were here, yeah, I'd serve on jury. No, it wasn't easy. It's not meant to be easy. It's important.
Which we covered.
I just have to explain the rules enough and then tell you don't get your feelings hurt when you get back there and begin the discussion. The instructions I gave you so far would be relatively common in most trials because those are general rules for how to do the job as a juror. The next set of instructions in the middle, I call substantive instructions. These are the law that applies, the rules that apply to this set of facts, these claims. You'll have sets of these instructions to go back over. So I have to read them to you in the party's presence, but you're not expected to remember all
Yes,
this.
Kristen.
You'll have your opportunities to go back over it and get schooled later. So these are the substantive instructions. Again, two claims. One's called defamation. The other's called invasion of privacy based upon this false light publicity. They have separate instructions. I put them right next to each other, but the rules for the one claim are not the same as the other. There's overlap, but they are a separate set of rules. So don't apply the rules for defamation to the false light publicity claim because you went across the line of their two separate causes of action. With regard to defamation, each plaintiff claims the defendant defamed him or her that then caused them damages. To establish defamation, each plaintiff must show that a statement, that could be oral, written, video, was portrayed a fact that was published. So the statement was made or statement of fact was portrayed and published. Second, that the statement was untrue. Third, that the defendant acted with malice, actual malice, or reckless regard for knowledge of the truthfulness. and that they suffered injury. I'm going to break those four apart. Okay, so again,
Yeah.
statement was
False
portrayed as a
light
fact. It has to be
is like
published, so it's all
invasion
together.
of
That the statement was
privacy.
untrue. The defendant acted with either actual malice or reckless regard about the truthfulness of it, and then that caused injury.
That causes emotional,
Plaintiffs are considered
physical
public officials.
injury.
You heard a lot of that. So that's where the clear and convincing evidence standard applies. So what you're doing is taking on the element of the defendant acted with malice or reckless disregard about the truthfulness of it. That's the higher clear and convincing proof. So on that element, it's not just a preponderance. On that third element, it's thoroughly convinced about his motive for publication. Clear and convincing evidence means you're thoroughly convinced about the truthfulness of motive for making or publishing the statement. What's actual malice? This knowledge in the publication. Actual malice occurs when the defendant makes a false statement with knowledge it's false. The second part of that test is either published with actual malice or published with a reckless disregard about the truthfulness or not. So reckless disregard means that a defendant acted while aware that the statement was probably false, or that the defendant entertained serious doubts about the truthfulness and didn't inquire. The defendant's failure to investigate may be considered evidence of reckless disregard or evidence of falsity when the defendant had serious doubts about whether it was truthful or not. So actual knowledge of falseness or reckless disregard about something that's probably false. Those elements have to be proven by the higher amount of evidence. A statement is false when it's not substantially.
I've never seen it this bad
It's
though.
substantially true when the essence of the statement is true.
And I
when you
know
think
I've
about the
met
statement
him
as a whole.
before.
The defendant's statements or portrayals must be given their ordinary meaning in that context, in that circumstance. So you can't just pull a line out. You have to look at the whole portrayal of the statement. In deciding whether the statement is false, you're not to consider the defendant's subjective belief. You consider whether it's true or false from an objectively
Really?
reasonable perspective. So it's your perspective about truthfulness, not what the defendant thought at the time. Because we can all think of things that are unreasonably thought. So we apply an outside standard, an
I'll
objective
provide
standard,
context.
not the defendant's subjective belief. Now, this idea about the concept of truthfulness is where we find the fact that truth is a defense. So if the statement is true,
Yes.
then there could be no defamation.
That was before I started doing this.
Plaintiffs also have to prove that the statements were published, portrayed, made. Published means that the statement was read or heard by another person other than the plaintiffs. From the testimony, as a matter of law, the courts has determined that publishing or portrayal is not an issue. Nobody pushed back. It's not anything you have to decide.
I need to
I'm
warm
telling
up
you as a
before
matter
I
of law,
start
that
typing.
element is uncontroverted, that the defendant published, the defendant portrayed the statement. So of those four, one's been resolved by the court because there's no contrary evidence. Now you're down to analyzing those three statements, elements, if you will. You need to know how to differentiate between facts and opinion. In
Yeah.
a defamation claim,
That's
is
what I
important.
heard.
This is over on this side of the first claim, fact versus opinion. The distinction between portraying a statement of fact and portraying a statement as opinion is crucial. It's an important distinction. Portraying a fact or portraying an opinion. Only statements of fact can be the basis for a defamation claim. Statements of fact could be untrue, which is the nature of a defamation claim. If I'm expressing an opinion, there's no way to decide whether it's true or untrue, so you can't defame someone in expressing an opinion because there's nothing verifiable about it. It's an opinion. So a defamation claim has to involve an untrue fact. To determine whether a statement is fact or opinion, you apply these four factors in their whole context.
Looking
Yes.
around.
You think about, look at the
See
specific
if there's
statement, the
another
language and
shirt I
statement.
can put on.
Consider, importantly, whether that statement is verifiable or not. Then apply the general context of the statement, and then think about not only the context of the statement, but then the broader, how the statement could be received or heard. Start with the statement, is it verifiable? Consider the circumstances of the statement in its context, and then go farther out to the statement's circumstances in
Ooh.
general.
Heidel, I kind of want to
With
know.
precise wording.
I probably
Determine whether a reasonable hearer or listener would view the words as portraying fact
covered it.
or portraying opinion. If a
You're
statement
not
is
going to say
made
Casey's judge,
in
right?
good
I
opinion
liked
because it's not
him.
verifiable, there could be no defamation. If a statement is made and contains verifiable information, then it can be the subject of a defamation claim if the verifiable statement is untrue. If you find that the statement was portrayed to the public as a fact, that the portrayal was false, it's a fact that's false, plaintiffs have proven their case. If you find that it's not a fact, or that the fact was true, then the defendant prevails. This is why I give it to you in writing. General instructions.
Some
for
lady was
defamation
like,
of fact.
yeah, okay.
Those rules apply to that claim. These rules apply to the invasion of privacy false light claim. There's only one place where I'm going to tell you to overlap the instructions. but so don't overlap all the first instructions in the second bucket, separate set of rules. The person who invades the right of privacy of another person can be subject to liability and the harm that comes from invading that other person's right of privacy. The right of privacy is the right of a person to be left alone. It's the right to be free from the unwarranted appropriation or the exploitation of a person's personality or their private affairs in such a manner as to outrage or cause mental suffering, some sort of shame or humiliation to the person. Each plaintiff claims the defendant violated his or her right to privacy by publicizing false information that places them in a false light in the public. Each plaintiff must prove that the false light in which they were placed would be highly offensive. It's a highly offensive place to a reasonable person, not their subjective, but would a reasonable person find that they were put in a highly offensive place.
We
And
need like a
the
Venn
defendant had knowledge
diagram
of or
of
acted
this.
with reckless disregard to the falsity of the publicized matter. Reckless disregard, falsity, and actual knowledge are the same definition for the first section. So that part of the first section you can carry over. Actual knowledge,
WTH.
reckless disregard, and falsity, I'm not going to redefine. That part you would read over. But it's a different test. Was the particular plaintiff put in a false light by the false information? False light means the defendants know that the plaintiff, as a reasonable person, would be justified in feeling seriously offended and aggrieved by the
Right.
publicity. Seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when it's an unimportant statement that's made.
Yeah.
It's only when there's such a
Stayed away
major
from that topic.
misrepresentation of the plaintiff's character, history, activity, some fact
But it's
that
From
might be
what I
reasonably
hear, it's
expected that a
crazy.
reasonable person would be highly offended. Determine whether the statements made by the defendant would place a reasonable person in a position of false light, not merely whether the plaintiff believed they were in false light. So this is the objective perspective that we use for juries.
right.
You're the outside
That's what I'm
public looking
told.
in. Do you consider it reasonable or not that they would be highly offended? It's not their subjective belief,
Stay
it's the
away.
public's perception. To be highly offensive, the plaintiff must be justified in the eyes of the community as feeling seriously offended and aggrieved by the publicity. The statement must be such a major misrepresentation of their character, of their history, of their activities, of their beliefs, or facts about them, that they would be seriously offended in the eyes of a reasonable person of the public. False has the same definitions I gave you, not substantially untrue. The fact versus opinion distinction doesn't apply from that, so you don't have to do the fact.
Well,
versus
I'll
opinion
explain
analysis.
it to you
If you
later.
find that any one or more of the plaintiffs proved all the elements of false light invasion of privacy, then you would enter a verdict in their favor. If you find that any one or more of the plaintiffs did not prove all the elements of false light invasion of privacy, then you would rule in the defendant's favor. I'll say it again, there's 7 determinations on false light, there's 7 determinations on defamation, and you make them separately. If you find for a plaintiff on either one or both of their claims, then you go to the question of whether the defamation or the invasion of privacy caused damages. There always has to be a connection between the false statement and the damage, or the false light offensive position they were put into and the damages. A person who seeks to recover damages must prove not only that the other party caused the harm, but also that the conduct proximately caused them injury. Proximate cause is an act that in its natural and logical sequence caused the injury. There was an example of,
I think he's just
defendant
wasting
could have
everyone's
caused,
time
but
with
was something
this.
else actually the cause? You have to sort out whether the person's injury came from the defendant's conduct or came from somewhere else. With regard to damages, the purposes of damages are to compensate a plaintiff for injury, to their reputation, for any kind of monetary loss, for emotional distress, so it's compensation, to vindicate the plaintiff, which helps restore their reputation, and to dissuade others from publishing defamation statements or false light statements. If you find that any one or
Exactly.
more of the plaintiffs claims to be ruled in their favor, then you have to have the greater weight of the evidence, a preponderance of the evidence about the amount, not clear and convincing proof about damages,
Paul's
but
still
in your
alive.
deliberations, slightly more evidence in favor of the amount to award is the test, the burden of proof. Take into consideration all the facts and circumstances and evidence, decide what amount of compensation should be awarded to each particular plaintiff. These are the kind of types or examples for which you can award money. Harm to their reputation, including exposure to public hatred, public contempt, ridicule, or public scorn, and or loss of professional income and or out-of-pocket expenses, and or physical, mental anguish, pain, and suffering, loss of society, companionship, and friendship. Those are all eligible factors or categories by which to compare or measure damages. It could be that the award of damages is not easily determinable and you can't put an amount on it. You can still order what's called nominal or I'm going to use the word token damages. So if you find in favor of the plaintiff, then you have.
I'm sitting here and I'm just thinking, I have never, ever, ever seen a judge go more out of their way to advocate for one side specifically. There were some changes towards his attitude directed at the defense today that I noticed that were an improvement. But if you really want to know my opinion, and I assume you may want to know my opinion since you're here listening, I am like, I don't see how this is a good look. And Jess had mentioned earlier that this could absolutely open the door for appeals. I don't know how that works with civil cases. I have not covered any other civil cases. I've hardly been able to keep up with Karen's. I lived through Karen 1 and Karen 2 trial. That was my life for a few years. I ain't never looking back. I ain't never going back. And I would like to think that it's no different than like a criminal appeal, but I can't say for certain. And I know that each like the Ohio Revised Code, which is what I have to operate out under as a lobbyist, is different than every other state's. So how is it I'm on my laptop? Oh, you can just click on, if you're in the mobile stream, you can like click on my face and it'll take you to my channel, and you should see right on the front page of my channel 2 live streams going on. One is for the horizontal and one is for the vertical. All of my mods hate the vertical, but my viewers enjoy the vertical. So it's awkward. Welcome. How are you? Thank you for dropping by. The other thing I wanted to mention that I thought was interesting that happened to me today regarding this. A few people in here know this. I was communicating with the literal official account for the Libertarian Party. They saw my tweets and they offered to share my live stream today. I didn't check to see if they did, but they wanted me to tag them in it. And so I sent them a DM, and I think I did what they asked. But if you want to catch up on this case, I covered it yesterday, days 1 and 2, and none of the fluff. So it's pretty to the point, and it's on 1.5 times speed. And then today, which was a marked disappointment. I really was hoping today we would hear from Afroman again. I was hoping we would hear from his ex-wife and maybe even one of his kids, depending on how old those kids are. Because, like it or not, that sort of testimony resonates with jurors, especially if it was as traumatizing to have, I have to watch words because YouTube doesn't like certain words. the heavy machinery that was used when the police arrived. Okay. Peachy says, I have a feeling the jury is going to side with the plaintiff since they've taken a while to reach a verdict. So, interesting take. I believe that the judge did a good thing at the very beginning of this long-winded word salad lecture by saying that the jury needs to cover every single plaintiff individually. And I wouldn't be surprised if they are going through every single plaintiff and deciding if there's anything there based on the testimony. But I don't think you're really wrong. I think that could be a possibility, unfortunately, especially for Lisa. I don't know, you guys. I'm a woman, and I would have asked for 1.5 for the dude. If I was in this mindset, right, where I actually believed that something bad had happened to me, I would have thought that the guy who is being called pedo, you guys can figure out what I'm talking about. I would have thought he suffered more. And it's stupid, in my opinion, that we're trying to figure out who friggin' suffered more. Okay. There's only a few minutes left of this. Let's see if he says anything interesting. Then I have an idea of what to do next that would help us in determining what may be happening behind the scenes.
Have essentially the opportunity to go from 1 to wherever nominal or token to be the 1 or 10 or some low amount as a statement that they prevailed and entitled damages. But you're not bound by anything more than 1 in your deliberations. But if you find for a plaintiff, then there has to be an award for damages, assuming there's a causal link between the defamation or the false light and injury or harm.
You're saying it doesn't apply to this. Like, what?
As a matter of law, the court determined previously that the claimed damage to the defendant's home was permitted under the circumstances of serving the search warrant. Therefore, you do not make a reduction for any damage that the defendant said happened to his home during the search warrant. The court previously found, as a matter of law, that that's expected or permitted as a result of serving the search warrant. So you don't subtract based upon whatever you think happened to his home. In your deliberations,
We had a
the plaintiff
meeting.
cannot have double recovery. If you find defamation and invasion of false light privacy, you don't issue an award under each
Oh,
category.
bye, Stan. Thank
Can't
you
award
so
pain and
much for
suffering.
your support
So just
today.
emotional distress
See you
once and then
tomorrow.
emotional distress twice. You would issue one order as long as there's either a claim for defamation or a claim for false light invasion of privacy. Don't double up if a plaintiff prevail on both claims. Your verdict form doesn't really make that possible. You'll get there, we're getting close. Another concept that came up earlier was something called punitive
He's
damages.
such a sweetheart.
You are
I
advised
love
that punitive
Stan.
damages are not a part of the deliberations given to you right now. I haven't talked about punitive damages. Punitive damages are meant to be punishment damages for conduct. That's not a part of your deliberation. You're deliberating what we call compensatory injury-related damages. An award of punitive damages can only be given if there is a compensatory damage award. If a compensatory damage award is given, then you come back with a different set of instructions and you have arguably a second deliberation about punitive damage. You don't have to award it, but they aren't all lumped in. So don't think in this first phase, oh, the funny runners are really mad. That's not where we are. If you find any plaintiff prevails on either claim and it caused injury, compensatory, actual repair damages, if you will, are what we're here for, not punishment. That's a second deliberation. The verdict forms aren't that hard to understand once you know what you're doing. Each plaintiff has 3 pages. Page 1 is the claim for defamation. With the jury being duly impaneled, find in favor of, and then it says Sean Cooley or defendant, circle 1. So you have to circle whether the defendant prevailed on Sean Cooley's claim for defamation. Then there's signature lines. Regardless of that verdict, you go to the second claim. So the next form is we the jury find in favor of Sean Cooley or defendant for the false light claim. The instructions basically now go to the next page. If you find for the plaintiff on either of the first two forms, then you go to form number 3, which is damages. Damages is one line where you put a number in. You can take notes and you can split it out. You can do calculations. You can decide how you get to it. But there's one line. So that would be for Sean Cooley. And it says Sean Cooley on the first 3 pages. Then the next 3 pages say Justin Cooley, same 3 pages. So the first 2 pages find in favor of that plaintiff or the defendant, circle 1. Next one, in favor of that plaintiff or defendant from the second claim, circle 1 of those options. And then you go to the damages form only if the plaintiff prevailed on one of the first 2. They're all numbered. They all have names on it. It should be easy to follow. You can tell me later.
Is that it, sir? Can this please be it?
What do you do when you go back there?
Thank
The
you.
first thing you officially need to do is pick a foreperson. Now, the foreperson is not the shop foreman. They're not the boss.
This
They
is
don't
what
tell you
I
to do.
need.
The foreperson
you
job
guys
is
to
organize
do.
the discussion, engage people, keep track of the exhibits, be the committee chairman. But the foreperson doesn't convince you to do what they want. They organize the discussion. There's no way to pick a foreperson. You can arm wrestle, throw fingers, draw names out of a hat. Don't go to the bathroom first, because you very well could come out the foreperson. I don't care. I've heard people say that. They pick them because they weren't there. It doesn't matter. I can't tell you how to pick one.
That
Just pick one.
happened to me once,
Throwing fingers is fine.
not
Just
for
pick one.
jury duty,
You
but
probably already know who's willing to do it, or maybe you've talked to each other enough, or you just say, sorry, you lose, you're in. But it's just organizing discussion. That's all it is. Just organize the discussion. Make sure nothing leaves. You'll have in your possession the verdict forms, the exhibits. You'll have copies of these instructions. Keep all that back there. When you come out, the only thing left to bring back out here should be all these verdict forms. Leave your notebooks back there. Everything else in the foreperson should make sure that goes on. How do you deliberate? Generally, the advice to you is to go back there and start talking about the case, replay the witnesses, but don't just say, I think something ought to happen. When you come out with your first opinion and then start discussing it, a lot of people realize their first opinion is not their best opinion. But once you threw it out there, then you got to figure out, how do I get my pride back and retool? So generally, don't go back there and just say, here's what we ought to do. What do you think about this witness and how does this one come across? And do you understand the rules? And start into this discussion process, however you can do it. But eventually, then you're going to need to start getting to the point where you see a consensus is being built. If you immediately express an opinion, changing is sometimes hard. So work together to build a consensus. Consult with one another in the jury room, deliberate with the view of reaching an agreement. You can do so as a group, but without surrendering your own conviction. Each of you ultimately has to decide this case for themselves in this deliberation process. You might find somebody leaning on you to change their opinion. That's good, unless you feel pressured against your will to change your opinion. If they come at you with good arguments, maybe you should rethink your position because their arguments really are good. So a certain amount of give and take and tension is usually the sign of a good deliberation. Just don't take it personally.
oh,
Never surrender your own personal convictions just to get along. Don't be influenced by considerations of
so I was not correct when I said that I've never dealt with a civil case before. My mom, they didn't. I'm allowed to talk about this because no one had me sign a paper, which was on their part. Jury is still deliberating. Mr. O'Keefe, thanks for watching. Please make sure to sub up and hit the thumbs up button. And my mom, she had a procedure done in 2022 and she almost passed away. And there was negligence all around. And, you know, medical malpractice lawsuits are like 1 in a million. They're very rare to win. But this was so bad when she was in the hospital having repeated surgeries. The surgeons would come out and be like, I made sure to document everything and take photos of everything because I think you're going to need it. Meaning they knew that I should sue. And this was in, like I said, 2022. Worst experience of my life. Had to cancel my wedding because of it. In Jamaica. And thankfully she lived. And we went to, we'd been in the weeds with the case. They decided that they wanted to mediate. And so I was pretty much the decision maker in all of this because my mom's perspective, she was not aware of what was going on during this. So I was the one calling the shots. And my mom ended up agreeing with me that we should just go ahead and mediate because who knows how a jury can go. My mom was 74 at the time of this plastic surgery operation, and a lot of people, would think, why would a 74-year-old go have plastic surgery done? You just She works in the industry, work in the fashion industry, and like a very long story short, my mom's settlement was gravely impacted because of the attorney fees. Now, she still walked away with a very good sum of money, but it's like it. Yeah. If you want to know more about it, I'll talk more about it.
Sympathy or prejudice, the law does not expect us to be robots and have
Less
no
than
sympathy,
10
no
minutes.
emotions, no prejudice, or no biases. That happens all the time. You have to set those aside. You're
Thank
required
you.
to disregard them, to make your verdict carefully, to weigh the evidence.
She
consider
wanted to
disputed
look
questions
nice
of
for
fact,
her only
apply the law
child's
to try to reach
wedding.
a verdict which the parties would be considering fair to both sides. Fairness is a big thing. Is this verdict fair to both the parties? Consider all the evidence regardless of who brought it
Thank you,
forward.
Heidel.
Do so with intelligence, impartiality, without bias, without sympathy, without prejudice. During the deliberations, if you have questions, you're welcome to write them down, which then comes to me, which goes to lawyers to get you an answer. Like a magic doorbell. Knock on the door. Okay. The bailiff's like within earshot. He doesn't have his cup up against the door. So like pound on the door enough to get his attention. He'll come back, get the question, give it to me. I'll huddle with the lawyers, get you an answer. So when you get back there's a problem. You don't understand something. You want more information.
I
You
love
can get
this
more information.
moment.
Like we'll try to make sure you're not starving. Like creature comforts will be provided.
Happy
Like,
Meal
we're going to run into the lunch hour. So
Snickers
there's a
bar.
way care of it. I heard it yesterday. They'll do it today. So like we're going to want to cover all those bases. The clock is yours when the deliberations start. You
This
watch
part.
TV, pay attention to the clock, right? I don't have a clock because you do. So how much time you need is up to you, not up to our expectations or our time commitment. We got to make sure that when you deliberate, you don't do so out of like human denial or fatigue. So yeah, we're going to watch to see how that goes. If you might have me send you a question saying, is everybody fine? Are you awake? Do you need coffee? Do you need food? What do you need? One jury kept going, my personal record is 1:24 a.m. because that's what they wanted. They didn't want to go home. They were not coming back tomorrow. Because they were
So
locked in and doing a good job. But it wasn't my clock, it was theirs.
I wouldn't be
Until the verdict
surprised
is
if
announced in
the
open court, you
jury
not indicate to anybody what it is. When you knock on the door saying we have a
doesn't
verdict,
want to come back
the bailiff
tomorrow.
will come, he'll tell me that you have a verdict. The foreperson brings the forms out here. And you hold on to them, everybody's here, and then we open the verdicts in front of all the parties. Don't say, oh, so-and-so and this outcome, because the bailiff doesn't want to know that. And he shouldn't know that, because it has to happen in this room. Up to this point, like I told you, like not to talk to people, that still applies. Anybody outside the jury, that's off limits. If we deliberate today, you went home tonight, came back tomorrow,
This makes me
the
so
rules especially
happy.
important. You can't tell anybody anything at all. Once the case is done, you can, in case I forget to say that. With regard to deliberations, I've got 10 of you and 2 extras. So the 2 on the end, 17 and 19, you're alternates. So you don't deliberate, but you're not done. You're what we call insurance. There's no guarantee in an hour
Probably
somebody's not going to get a call that they have to go, or that they hit the floor, or somebody had an accident, or
50%
the baby
and
came
then
early, or
50%
whatever it is.
genetics.
So you're not done. You're charged to not talk and to just wait. It's a luxury to have extras. I understand what I just did to you. I get it. But the number of times the jurors slap back in is not the majority, but it's enough that we're glad to have you for a reason. These folks get locked down and something happens along the way. We can't lose 3 days of trial work because somebody went through a stop sign or had a flat tire on a curvy road. Then all of a sudden you're back. We start all
Don't
over,
drive down
and the
curvy
case gets
road.
done. So make sure the bailiff has your phone number. If you can be within like 15 minutes of the courthouse, I don't know what that means. If you live farther, just make sure Chris doesn't have to drive far to get you. He's not going to anyway, right? But you think that you don't want to cross him, kind of guy. Anything you want me to deal with in the instructions, Mr. Taylor?
I had 2 minor issues.
Okay, we'll talk over there. Mr. Osborne, you got anything?
I do have some issues.
Okay, we're just going to see what I didn't do right. Or we're close.
I don't think I'll ever be picked to be on a jury because of this. They want someone normal. I am by all means, like when it comes to this true crime and trial streaming, I am not normal. So I would say I would taint the jury by bringing in my previous experiences and what I consider to be knowledge. You know, I didn't go to law school, but
The vote is 6 out of 8.
Also,
not 8
I'm
out of 8. It's the next paragraph down. So I got 8 jurors. When you go back there, 6 and 2 is a vote in favor or opposed. So you always have to have 3/4. So if you take a vote and it's 6 this way and 2 that way, that's enough votes. It does not have to be unanimous to prove a case. In a civil case, it's 6 out of 8. That big deal? Yeah. That would forget it. Yes. It's 6 out of 8.
that's the other reason why we decided to mediate and come to a settlement with my mom's situation, is because it's 6 out of 8. So he picks 8 people to go back in the room and deliberate, 2 alternates, and the if 6 people agree with each other, that's it. Ball game. That's terrifying.
So you can have 2 people say, I don't agree, and if 6 people do, that's a verdict. And then the emphasis for the 2 alternates is not only not talking is important, but not talking to the media is
You
important.
lucky
So being hounded,
duck.
it's anybody in the universe. Because you're still in the panel. And
What
then
was
if
it
you
about?
reach the verdict without you, you're going to get a call saying you're done. And now if you want to talk about it, you can. Anything else, Mr. Klinger?
Nothing from us, Judge.
Mr. Osborne?
Your Honor, I just renew any objections for the record, but nothing else on that.
Fair enough. Overruled.
They wouldn't want me anyways.
There's a few
Because-
typos. It'll be like 5-10 minutes before it gets you some sets of instructions. When you look at the instructions, if you have a question about something, read the whole paragraph, not just the one sentence. Like you always think, I want to know more about something.
Because of
The
my
answer might be 3
disability,
words.
they wouldn't
So read
want
the whole
me on
paragraph to do it.
a jury.
So you start your deliberations. We'll get the exhibits back to you, cleaned up sets of instructions. And thank you for your attention so far.
Okay. So that's that. So I figured that of all, I would ask you guys if you have any questions first and foremost before I do what I was going to do. But while you guys are typing out any potential questions, let's move forward. And I know Peachy's just, I know you probably just heard this a few hours ago, but I'm going to show it to my stream. I thought I would show you a something that was recorded 5 days ago from the Watchdog Wire. Hopefully, I'm going to send him a message after I show this and let him know that I put this on my channel. But here is his information if you would like to sub to him. Just covering my bases. I don't want him to be mad at me. That's the Watchdog Wire. All right. Let me go ahead and share this screen. He sat down with a news crew and did this the other day, and I thought it would be interesting to watch.
Just be a regular American in court. I won't, I'm gonna just go fight for freedom of speech. Mine eyes seen the corruption of the Adams County cops. The world famous Afroman kitchen where Officer Pound Cake was born. I don't want nothing bad to happen to these police officers. I don't want them to go to hell and burn forever. I don't want them to get killed or beat up. They're still messed up from when they was roughing through here looking for kidnapped victims in my suit pockets.
Has anybody ever apologized to you? Have any of these people ever apologized?
No.
It's Thursday, March 12th, and I just had the honor of spending about an hour and 45 minutes with Afroman, also known as Joe Foreman, whose trial is coming up, CVH 2023-0069, starting on Monday, March 16th. So this is all the fun video we had talking about the trial, taking a little tour, and this is a great guy, a fun guy. I encourage you to pay attention to his case because he is a First Amendment lawyer. He had his house raided inappropriately, in my mind. Nothing was found. He then basically exercised his First Amendment speech criticizing the police for what they had done and is now being sued by a bunch of Adams County Sheriff's deputies. I'm sitting here with Joe Foreman, better known as Afroman, and his counsel, David Osborne, because the case of Joe Foreman being sued by a bunch of Adams County Sheriff's deputies, case CVH 2023-0069, is actually going to trial on February 16th, on Monday, February 16th. So it's an honor for me to be here. I told, I've listened to this man's music. I never did before this stuff came up, and it's a lot of fun enjoying the music. And I tell you, I am a First Amendment absolutist. What happened to you was wrong, you using these people's images, and we haven't even talked yet. I'm just spouting off right here. To make a First Amendment protected point about what happened to you and how it was wrong is something we should all fight for. When the law enforcement overreaches, to me, they should be apologetic for their mistakes. And I still remember, I didn't even say this to you, I still remember an interview I saw with you, and you said one of the things that bothered you the most is you asked the guy to help you put the door back in the frame, and he told you he didn't have to do that and walked away. So I'm here with both these gentlemen. You got your trial coming up. Let's kind of, we haven't really broken down what we're all going to talk about. Afroman here just said, let's wrap and let's talk and see what we want to talk about. So maybe we'll start with Mr. Osborne talking about the case coming up on Monday. Maybe just give an overview on what the case is. By the way, I'm sure he's not going to talk and reveal any strategy associated with the case or any secret stuff. But Mr. Osborne, why don't you just give an overview of the case and where it stands?
So this case was filed in 2023 by 7 officers of the Adams County Sheriff's Department. They were all officers that took place in the search on August 21st, 2022. And so what has happened is that procedurally, they filed their complaint. There was a motion for judgment on the pleadings. There was some filings back and forth with that with the original 2 attorneys, Tyler Cantrell, who's now one of our prosecutors, and also Bruce Rivers at that time. The court at that time did a ruling dismissing 2 of the 5 claims that they had, mainly that their images could be used, that they had no commercial value. And that judgment entry is on file with the court. From there, it went forward. The insurance company, well, I should say back up, Mr. Foreman through Bruce Rivers did a countersuit. From there, the countersuit, as it involved damages and stuff in relation to the search, the insurance company that defends the officers came on board at that time, and they started for defense only. They filed some motions. There was some pending as far as if qualified immunity pended. That was never ruled on. We moved forward, went through discovery, which we had put on pause for a number of times. We did depositions of everybody. Those have been filed with the court. And we have gotten the ruling now from our new judge, Judge Hine, that has pretty much dismissed all the counterclaims of Mr. Foreman, except for one, which was abuse of it was a claim basically that the officers did not have basis to file their first 2 actions that were dismissed. That has not been ruled on. It's still pending. It creates it such that the order we got is not a final order, so we cannot appeal it yet. We have to wait for the conclusion of this case so we can appeal.
Okay, so I think a lot of people know from watching the news. What's funny is I told Mr. Foreman, Afroman here, that I didn't originally catch on to his case. I felt like it was more covered almost in the national media than in the local media. But when I got into it, so the claims of the 7 deputies, those all revolve around you. They all revolve around using their image and likeness in merchandise and songs and other things.
Out of the 5 claims they filed, 2 did. 3 claims. One is invasion of privacy for false light. In other words, basically you, through your actions, you make a person look, you put them in a false light,
okay,
injure their reputation.
Okay.
The other one is basically the effect of publicizing something relevant to your private life. So if a person was a diabetic and they didn't want people to know, that would be a private life thing.
Okay.
And then the third one is defamation.
Okay.
The interesting thing about those is each officer obviously would have different damages for that. And some of the claims don't make sense when you look at certain officers.
Okay. Well, so what they're saying is so the video, just so everybody knows this, the video that you used in your music videos and so forth, that was from your own home surveillance system.
Yes, sir.
Correct? And was part of it from like your wife's cell phone or something like that as well?
Yes.
Okay. So it was your video, it wasn't their video. And so so what is it effective? And I know you're not going to respond to certain things, but you said I could ask anything I wanted. So they're basically saying that putting out video of them doing their job as policemen somehow puts them in a false light and makes them look bad?
That and some of the posts that were done on Instagram, YouTube.
Okay.
Like the perfect example one doesn't make sense is how would calling Sean Cooley Officer Pound Cake put him in a false light?
Right.
I mean, it's a funny joke video.
Well, to me, that strikes us as something. I've been involved in a couple of First Amendment cases. That's very First Amendment. If I wanted to say he was an idiot, he was a doofus, he was a clown, he was a joke. Those are all First Amendment protected expressions relating to somebody that we can make, as far as I'm concerned, we can make, but apparently, that creates some issues for some people.
Well, I mean, we do it all the time in the media. I mean, you got Sleepy Joe Biden.
Yeah.
What is Trump calls him Auto Pen Biden?
Yeah. So
I mean, there's no difference there.
So the officers involved in this are Sean Cooley, Justin Cooley, Sean Grooms, Lisa Phillips, Michael Estep, Randolph Walters Jr., and Brian Newland. Are those all still, to your knowledge, you know whether those are still Adams County sheriffs?
So they were all Adams County sheriffs at the time this took place. Brian Newland was a detective. Lisa, I believe, was a sergeant. Mike Estep was a sergeant at that time. I don't remember if Randy was. Now, as of today, I want to say Justin Cooley is no longer with them. I think Sean Cooley is no longer, and I know Brian Newland he moved to a different department in Cincinnati.
Okay. Now, originally, this case was Judge Jerry McBride, which, I'm from Claremont County. Judge Jerry McBride's a retired judge from Claremont County. We can talk on or off camera, but we can talk about him, okay? And now you've got Judge Hine, who's these are both visiting judges. And for people that don't know it, when a judge recuses himself for whatever reason from a case, like say Brent Spencer recuses himself because he's buds with the sheriff or something, they bring in a visiting judge. And in Ohio, that means typically a retired judge who can no longer run for office because they age out and they can't run after they're 70. So it always creates to me like it can be a tough situation because you get a lot of judges that are kind of out of practice a little bit. They come in, they're also older, they don't have the same support staff that they did, and they're not doing it as much. You probably, I don't know anything about other than watching your videos, but if you haven't gone on tour for a long time, the first show after you've not been on tour for a while is harder than probably after that. You got to get back in a rhythm of it. So what's your impression of Judge Hine so far on this case?
So far, Mr. Hine, or I should say the Honorable Judge Hine, seems to, my only interaction would have been in our conference we had by phone where he wanted to talk about, and we talked about how the trial would go.
he is very much wanting to make sure we get done on time and be as efficient as possible. He's kind of previewed the idea that he's going to try to limit some of the evidence and the idea of what's relevant, so we stay on topic and we can move through the trial quickly. We talked a little bit about jury selection, what he would consider cause to kick someone off.
Okay. So you're anticipating that the trial, I think you told me that the judge thought the trial would be up to 5 days.
We have allotted 5 days in scheduling.
Okay.
The judge wanted to see if we could squeeze a little more time to make sure we don't go over. The idea being is that our courthouse closes at 4 o'clock. He was going to see if we could stay open to 5 because, as he said, that's an extra hour a day, and over 5 days, that's half a day.
Okay. So you've got, so day one would be jury selection or part of that day. And then up to so many days after that. And just so anybody watching this knows, you can come and watch this if you want. Get out there, come to the Adams County Courthouse, sit there. They have a great video system in that courtroom, so it's going to make great videos. So make sure you wear your best suit. But you can come and see how it works. You can come and watch. You can come. You obviously don't be disruptive. Don't do anything. Don't be causing any trouble or anything like that. Don't be cheering or doing stuff like.
I was planning on this taking longer because I needed to cover something that took at least 4 days for my A/B testing that I was doing. And once I found out that it was going to be over today, that kind of ruined my ability to test out stream modes, which is just horribly disappointing. Let's go with this a little bit more. If you guys have any questions or something that you think I should show, please let me know.
For disrupting the court in any way, if you're an Afroman fan, but you can come and watch justice play out. And you're planning on, so this case will involve many or a lot of these officers having to testify, or how does that?
As the amended witness list from the plaintiffs today, all officers were listed as witnesses.
Okay. By the way, what time does it start on Monday?
So jurors will show up roughly around 8:30 to 8:45. All counsel will be there at 8:30. That's our standard thing. I usually try to show up a few minutes before that.
Okay.
To set up on the table and everything, be ready to go. From there, we would expect jurors to be called in.
I'm more getting at, if you were a member of the community and you wanted to come and watch this, what would be on Monday? Because I know there would probably be some stuff dragging out before it gets going. What time would be a good time to show up?
8:30 is when I would show up.
8:30. And then probably on subsequent days, you have to kind of pay attention because they can always change when they're going to start the next day. But 8:30 is probably a good time if you want to watch this case play out. So, okay. As far as you're concerned, Afroman, Mr. Foreman, I mean, do you feel like, has anybody ever apologized to you? Have any of these people ever apologized?
No. Very unapologetic, intentionally unapologetic. And matter of fact, the guy that waddled his head and told me he wasn't required to put my door on the hinges. This guy is the same guy that flipped me off when he raided the house. He's the same guy that, he hit that lady over there and he ran that stop sign and hit that lady. He got that same reckless attitude about everything. And he's unapologetic.
Oh, so that's him flipping off the camera, basically.
Yes.
If you take a look at the kitchen surveillance video, you're going to see he goes past the fridge, he'll walk back, and then you'll notice the finger come up, he'll look at the camera.
Have you ever, I asked when I was driving here, I asked Grok AI in my car if you had any record, and criminal record, and it told me no, and I'm not asking you to jump into some detail, but have you ever been involved in anything in Adams County that you were causing trouble or that have any reason to think you're up to no good?
No.
Okay, so it just strikes me as, and I know we can talk about where did the original allegations that can't come from that resulted in a warrant, and I think some of that will probably come out in the trial. But just so we're aware, there was and correct me, Mr. Osborne, there was a warrant that caused the search to take place, or do you want to explain how
a search warrant was issued, not a warrant?
A search warrant, I'm sorry. I'm not a lawyer. So search warrant, but maybe explain how the original up to the point you're comfortable, how the original search warrant came about.
Well, I can explain some of that because unlike the filing that was filed yesterday, basically saying that defense wants to relitigate the claims that were dismissed by Judge Hine, that is not the case. Those claims will be litigated in the Court of Appeals. However, to answer some of that question, in depositions, and I know I put together a decent timeline in my response to their motion for summary judgment on that. What we find out is the officers, Mike EST and Sean Cooley, went to talk to what would become a confidential informant. They talked to that person about holding a large quantity of weed. From there, they call Brian Newland. He comes, everybody talks to her for a minute. She is asked to come down and give a statement at the police station. They let her drive herself there. From there, Brian Newland takes a slight detour, looks at the house here, goes there. There's an interview. There's technically 2 interviews at the police station. The first one was not recorded. The second one was Mike EST and Sean Cooley going in and getting more statements. The best parts of those interviews was put together into a affidavit that Brian Newland signed and presented to Judge Roy Gabbert to sign. And Roy Gabbert signed it, and then the officers executed the search warrant at that time.
Okay. And so when they got here, was the gate, like I've seen in the video, in the music video, the gate was closed and locked when they got here?
Yes, sir.
Is there like an intercom or something down there? It's a fancy gate. It looks like a fancier gate than it was then.
Yes.
Now. Okay.
Yes.
But was there an intercom or anything down there?
No, I was on tour.
Okay. So, and okay, so at the time, nobody was in the house, or was your wife in the house at the time? Nobody was in the house. And then at some time, I guess your wife or somebody came home, and that's where the cell phone video came from?
Yeah, yes. This is my company, it's my home now. My ex-wife.
Okay.
She stayed next door. So I was on tour. So, my company / house, I had it locked up while I was out on tour working.
Okay. And then so somebody came when the cops were in here.
Yeah, she noticed some weird stuff going on when she was going, to her house.
Okay. So at the time, then you see these videos with them all with their guns drawn, looking like they're taking out Maduro in Venezuela or something like that.
Yes.
That was at that time, nobody was even in the house?
No.
So they were just, and I can't find any evidence that you did things in the past in Adams County in particular that would have been put him on notice. A super dangerous guy. We better come in ready, make sure to have him cocked and ready when we come in. The basis for this, do you think that and I don't want you to say stuff and your counsel can tell you not to say something, but is the motivation for it, is there some reason why they were looking to find a reason to come and toss your place, or what's your premise as to why they were so motivated to do this, to go through all of this?
There's a side of me that wants to get emotional in my fishbowl and feel like they're picking on me.
Yeah.
But from what I'm seeing, these guys are overall corrupt. Like they're I feel better now because they're not just picking on me; they're violating everybody.
Yeah.
But the thing is, everybody don't have the platform I have to put a spotlight on it.
Well, it's and you might know, Mr. Osborne might have told you this. I've been on that the prosecutor here doesn't actually live in the county, and I got pulled over in town for no reason by Mr. Grooms, one of these people for no reason, and I don't think he knew what to do because I'm just like, you can only hold me here so long before you have to either tell me what you pulled me over for. I pulled you over because the sheriff told me to. Were you out on patrol? No, I came out of the office to come pull you over. I mean, it's just like they're afraid of somebody that would have, and it's like I've seen this in a lot of government things, and I'm not making a reference specific to this case because I don't know. But it's like they're afraid of people who would have maybe an independent thought and have some means to resist should they try to do something. Me, a lot of times it's because I'm not from there. I'm not from Adams County, so it's harder for them to harass me. I'm not in Adams County. You perhaps because of the huge following you have and the notoriety you have. But it's just bizarre that I just don't understand why somebody wouldn't at some point just say, we're sorry, what happened?
That's how much of a poor sport they are. They probably didn't shake hands after the basketball game when they was little kids.
Yeah.
I don't get mad at somebody for doing wrong. I get mad at them for not apologizing after they did wrong. They got erasers on the end of pencils because you're going to make a mistake. None of this stuff, the raid didn't make me, nothing made me upset until he waddled his head and smiled at me and said, we're not required to do that. That's the one who did that. His name is Randy Walters.
Okay.
That's the guy who's flipping me off. That's the guy who hit that poor lady. You can pull it up.
So I've been informed about a crash, a T-bone crash that happened, and I'll be looking into it further.
Yes, his name is Run the Stop Sign, Wreck It Randy.
Hold on,
we're not required to do that, Walter.
Are you sure that you're allowed to have this First Amendment protected viewpoint here in Adams County?
They told me I had freedom of speech. They might have been lying to me, but they told me I had freedom of speech. So they told me I was freedom. They said I was free to say, run the stop sign, Randy. Run the stop sign, wreck it, Randy. We're not required to do that, Walters.
And that's, by the way, I don't mean to harp on it, but when I watched all those interviews of you, that's when I could tell really what a nice guy you were from the standpoint of that you said, I'll tell you two things. I'll say it all. What I thought is, I felt like on some of the national broadcasts, they were asking a lot of questions about, is it a racial thing? Is it this or this? And your answer that I heard again was like, I never had any problem in Adams County. People tend to like me. I go into town, they all like me. I'm not going to go down that path. And then it also stuck with me, the thing about how much if that guy would have just said, yeah, dude, let me help you get the door back in there.
You know what? I'm going to go far as to say this. He could have just had a polite attitude and said, you can file this at the sheriff's department. We'd like to apologize. He could have just had a better attitude. Right. He cracked a grin. He got off on telling me that he wasn't required to fix it. He kind of was happy that he did it. You see him flipping. Yeah. You see him flipping off the camera. So this is the type of person employed.
Who flips off a camera?
This is the type of person employed by the Adams County Sheriff. He's reckless. He's unapologetic after being reckless. Not just with me. It's not a racial thing. He's unapologetic about hitting that lady at that stop sign. Nobody don't even know. And then he's unaccountable. He's not required to be accountable. So,
well, that's the thing too. That I think bothers so many people is we have a government in so many ways is never accountable, never apologizes, never says a sorry. And I like when you say about a pencil having an eraser. I tell every one of us fucks up, right? Yeah. Every one of us fucks up and makes mistakes. You can go ask my wife and son, and I do it almost on a daily basis.
Yeah.
The question about it is that shows your character is how do you respond when you fuck up?
Yes.
And frankly, when you talk about his attitude, it just shows that kind of character of, what gets me is you're almost like he was pissed off that you were innocent. Okay, because his afternoon got ruined or his evening got ruined because he wanted to see a man. Shouldn't he be gleeful that Afroman is innocent? There was nothing there. We didn't find anything. Any allegations against him weren't true. shouldn't he be happy? But when you get law enforcement that's like they have a scorecard and they're upset they didn't lock you up and find a way to get you, then that's not good. Law enforcement should be thrilled when they execute a search warrant and to find a person is innocent of doing something wrong.
See, that's half the problem, I think. Attorneys look at it, it's all win or losses. The prosecutors, did I win? Did I lose? It really shouldn't be about winning and losing. It should always been about, did you get the right outcome?
Now, I saw I believe I saw in your music video, Sheriff Dick was one of the cops here.
Yes.
But he's not, was his image ever used in stuff you did? And
Yes. At first, I named him Sergeant Sam Sausage Head Eminem Elliott. You know, he kind of like a combination of Sam Elliott and Eminem.
Yeah.
Like Eminem if he had like gray hair. But inside, I was playing.
You know, that's actually, when you think about it, that's a good.
Hey, but I didn't know his name was Kenny Dick because I would have. I was just naming, some dude on my video camera. I didn't know his name. I was like, oh my god. And then I was like, hey, oh my god. I was about to make a song. My lawyer wouldn't let me do it, but he was running for. I was gonna be like, don't.
Okay, I want to hear.
Let Kenny Dick fuck up Adams County. I had to, but I couldn't put that one out. So.
There is a certain amount of stuff that, if you look at it, there is a number of officers that was part of the search that are not plaintiffs in this case and did not join the lawsuit.
Okay.
Mr. Dick was one of them. There was a couple others.
Okay. What else? What I'd like to do is then do like just a little tour around to the extent you're comfortable showing where.
Okay. So, I wanted to mention, what did I want to mention, you guys? We were talking about Coco and this dude. Why didn't they call those officers? That's a very good question. What did I say that I would explain? I forget. Sorry, I just got a really upsetting message. A family situation. I know better than to look at my friggin' phone during streams, but it comes up on my screen that I'm working off of. I have another screen over here showing me if there is any updates on this, because with my luck, I would end the stream and this would, the verdict would come in. So I'm hoping to give it until at least 6:30 before calling it a day. But if we have any information or news, then that's gonna determine if we continue to go longer. Okay. I believe Ahmad brought it up. I'm not sure. I'm sorry, buddy.
Where was the lemon pound cake sitting, and what door got kicked in?
Yes,
yeah, and,
okay.
and we can do that real quick.
Yes.
But before we do that, anything else you want just about the particulars of the case? So all next week, your good time to arrive at the courthouse will be 8:30ish to see the Afroman trial. Do you have in the music video? I haven't seen it here. I just walked in, we sat down, we started talking. I saw all those suits. You have it all set up for what suit you're going to wear each day next week?
I like options and I like themes. You know what I mean? So if it's St. Patrick's Day, I like to, hey, be festive. You know what I'm saying? I'm talking about freedom of speech. I like to be patriotic.
Yep.
I like to go with the flow.
Well, by the way, and then I could say, I don't know if you'd be allowed to, but I don't know if you're going to bring one of your chalices type things into the courtroom. That might be at the top.
Unfortunately for me, my American chalice is in the repair shop. So
okay.
I'm going to just be a regular American in court. I won't, I'm going to just go fight for freedom of speech. And
okay. Before we finish here, in terms of touring, new music, stuff going on that Afroman fans would care about, is there any kind of a quick update on shit you got going on or things going on that people should be aware of?
Yes. Mine eye seen the corruption of the Adams County cops still in.
Nope. I don't want to get in trouble. Copyright.
Just be like, oh, fuck, every one of you get out 125. We're just going to fucking clean this up. We'll take it out of our money. Even if we fucked up, we're going to. My point is, it's like every little thing was like a deal, like just bullshit in there. it's like, it wasn't like some huge amount of money. You would think the people involved in it would just be like, we all kick in $50 and then it'll be square and we don't.
And that's what, who miscounts $15? Who miscounts $20? Who miscounts $50? Who miscounts $100? Who miscounts $200? Okay, I'm sorry.
Maybe if it's all singles, then it's 200.
I was sent a copy of the report this week that the detective did in the search of that. It's kind of interesting because having looked at it, they do the search. So they do an inventory to check everything there. They find that out of 66 envelopes of money, 7 are miscounted. Now, the interesting thing is they say they're only miscounted by, less than $10 each way. Yet then you turn around and you look at Joe's, and Joe's is miscounted by more than 10. And further, when you look at the miscount of it, they say the first one, he's like, okay, was miscounted $390 in evidence 1. In evidence bag 2, he's like, it's off $10. And nothing in the report tends to indicate which officer was doing this, what kind of procedures they did to fix it. I mean, there's a lot of questions I have because it should have flagged it just right there. Everything else, well, let's just put it this way, 10% of your inventory is miscounted, 7 of 66, and they're only miscounted by 10 either way. And now we have a miscount that is significantly more than that, but it's okay. We're not going to look into it more. We're not going to interview people. That to me is what bothers me about the investigation. I think he did exactly what he was asked to do, but I don't think they asked him to go beyond anything and say, okay, look at this, tell us how we can fix this, what procedure should we put in place? I mean, that's what law enforcement is. You make a mistake, the law changes, what do we do?
Right.
You turn around and you say, okay, you cannot do this anymore, this is the correct procedure. You go forward. You don't sit there and go, well, everything's good and we're not going to change.
Okay. All right.
Let's
So
see
let's take a look at where the lemon pound
Okay,
cake was
good.
and where the door got kicked in. All right.
A few moments later.
All right. This is the Afroman kitchen.
Yes, the
Look
world
at that.
famous Afroman kitchen, where Officer Pound Cake was born, where he became famous. Yes.
And is that's actually the same cake from back then?
No, this is a fresh one. Officer Pound Cake, he confiscated that cake. I tried not to holler about the cake. He took $400 and my pound cake.
So, okay. So this is the kitchen where a lot of the video from your,
Yeah, come around and see this plaque that hangs over.
let me grab this here.
Yeah. Get a good shot of, this is I thought about tearing this house down and rebuilding it, but it's too iconic, like the song Lemon Pound
Lemon
Cake.
pound cake right on there.
Yeah, hanging right over the lemon pound cake.
So I wrote down here, your big songs from this event were Will You Help Repair My Door, Lemon Pound Cake, and Why Are You Disconnecting My Video Camera?
Yes, sir.
Right?
Yes, sir.
So if you have never heard those songs before, if you're watching this, you probably have. You got to go check them out.
Yes.
But don't forget to check out But I Got High first, because that's where Afroman started.
Then
So
after that, you'll want some lemon pound cake.
all right, look at all these. Whoa, look at all these
Yes.
plaques up here.
Yes.
All right. So the door getting kicked in. Where was the door?
This is the famous door. This is the special, priceless, larger-than-life door. Now, I had to get another door because they kicked in the door that was there, and I want to thank the man in Canada who got that one from me. So this is just a door. However, that moment in time was captured and celebrated. You know what I'm saying? By the
hold on, I got to get up foot. Now I'm seeing this stuff. I'm a little slow-witted. I got to look at
Okay,
that.
I'll just let you know.
Yeah, look at there's a picture of the door laying on the floor. So
So now the door is. Since they kicked that one on the floor, this is a way prettier, more
is this one stronger though? Have you tested this one for the kick strength?
No. Brian Newland and David Russell, whenever they get ready to kick in some more doors, they know just how to vandalize and kick in and destroy doors, steal money, and don't pay for it.
Okay. All right. So that's the key highlights. And the gate down at the road. When I'm going out of here, I'll take a picture of the gate. But
Man,
you have a nice gate.
Take a walk down. It's a beautiful gate. It's worth the
Okay, let's take the walk down there.
Okay, it's less.
And check out the gate.
I want to thank the people at Blue Goose for having a sympathetic soft spot in their heart and helping me repair my gate after the Adams County Sheriff refused to, or should I say, after Run the Stop Sign Wreck-It ran.
Afroman every 420 used to perform on my college campus, and it was a huge deal. Let me read what Peachy said. I don't want to put it on screen. I pick my battles. I avoid that case like the plague. Yeah, so I think the biggest reason why I'm not covering the case is because some of the more spoken, outward speaking people involved with the case, as silly as it sounds, I recognize this, have like a serious problem with me, and it's just going to make my life unenjoyable if I also, and you would think this would be a good thing for me to cover and bring awareness to a trial, but I have been so turned off by the way that I have been treated, and for that reason, I am steering clear of it, and I think that the people who are handling it have all the abilities to advocate and share their thoughts on what's going on.
Andy, we're not required to do that. Walters tore up my gate like he tore up that lady he hit over here in Adams County.
Hey, I love the
That's
First
a nice
Amendment
gate.
man that Afroman is. Look at this shit. This is fucking hysterical.
My God.
Hey, you know, I'm just trying to fix what they tore up. You know, I'm a peaceful man. I am a sport. That's a word everybody forgot about.
That's what I get from you.
Sports.
You're always so lighthearted, always laughing and
all
joking
need-
about it.
We all need. You know what? The funny part is, I don't want nothing bad to happen to these police officers. I don't want them to go to hell and burn forever. I don't want them to get killed or beat up. I just want to talk a little shit to them. And they're not even a sport.
Well, and maybe don't you think when people have bad character, which I'd say they have, you got to give them the business because maybe it'll cause them to reform. They need to reform. They need to feel that
You know what?
bad about what they did.
You know, you mess up, your dad talk a little crap to you. Your grandpa talk a little crap to you. You go out there and mess up. A cop is doing you a favor when he talk a little crap to you and don't write the ticket.
Right.
Yeah.
He's doing it, and I have to. Cops talk crap to me all the time, and you know what I do? I stand when I f up and he's right. I stand there and I say yes, sir.
Yeah. Yeah.
But I notice how when he f's up, he's not a sport. He can't stand there. He can't be corrected. He's above the law.
Yep.
He can't do any wrong when he's doing everything wrong. And I don't hold no grudge against him. Every day is a day for redemption. Every day is a day to wake up and be better. And I'm just tripping on the brat tantrum these brats are throwing. They are the predators and the victim at the same time.
Well, I agree with you 100%. And this is just a beautiful gate here. I just want to go back to this work on the gate with the officers. It definitely shows your support for law enforcement.
Hey,
by having some of them, you got law enforcement right on your gate.
I don't have them on here getting beat up, and
Right.
you know, I don't have them. You know, they're doing their jobs.
Yeah.
You know, and you know, I'm doing mine, just being positive in bad negative times.
Okay, so if you've watched the videos, you remember this garage. Look at this nice spread of cars out here in this place, and the beautiful color that stands out. When my little story I told you about somebody saying they were at a party you were throwing or something,
Okay.
I could tell they were really here because the garage doors were open and you could see the color from behind. So you remember seeing this. So wow, you want to take us through real quick each of these rides you got here?
Okay. You know what I'm saying? I've grown in my 40s and my 50s. Maybe I was malnourished as a teenager or something, but I grew taller and bigger.
Okay.
So the Cadillac cars have gotten smaller. I've always liked the Cadillac cars, but now the Cadillac car got even smaller. They made it like some kind of little soccer mom's car, and I didn't think I was cool in it. So I'm an anti-truck person. This is a fancy station wagon, basically. But I had to stop and I had to upgrade to an Escalade because
Okay. Okay. This is some sort of Rolls Royce here.
Rolls Royce.
You know, at first I got this one. You know,
Oh, you got two of them here. I doesn't even look
Look at it. That's like
At
an
first I got this
OU.
one.
with the lemon pound cake right up front.
You like that? Hey, what man's got it?
Hey, it's good to thank Mike DeWine for taking away the requirement to have a front license plate so you can put lemon pound cake ones on there.
Yeah, you know, I don't mind that requirement now. Okay, I see what you're saying. You have to be Ohio.
Yeah, you don't have to have an Ohio one up there so you can have your lemon pound cake
What's
one.
that guy's name?
Mike DeWine, the governor, signed into law that you don't have to have that.
Thank Mr. DeWine. Thank you. All right.
Oh my God, Mike
Thank
DeWine.
you, sir.
See that?
All right. I bought this one.
I need to
This is
send that
close.
to his
I got a good deal on
director.
this one.
Okay.
I really wanted the Phantom, but I couldn't afford the Phantom at that time, so I wanted the Ghost. So I got the Ghost. The Ghost, the roof is low, and it always smashes my hair. So I can be just dapper down and decked out, and I step out, and my hair's all gumbied out, or doing the catch fast. So that brought me to this one. You know what I'm saying?
Yeah.
I named this car Night Train, and the roof is taller. So this one
Works better for the
yeah,
front.
you know, I gotta it's a damn thing. It's called a snake. You know? Like this, you know. So when I get in the car, I gotta do the snake up. Get in there without messing up your hair. You know? This
Another Cadillac down here.
is the car. This is a '92. My '83, my theme car, my '83 coupe is getting worked on right now.
Okay.
This is a '92. I bought this from an old lady in Mississippi.
Okay.
It had 7,000 miles on it. She had a long driveway, and she used to drive it to the mailbox. Every day. You know what I'm saying? She maybe to the little dollar store up the street, and she didn't drive it. And I bought it. It had 7,000 miles
Wow.
on it, and I could jump in here and go to California today in this thing. You know?
Okay. Now this is a nice lemon color.
The Rolls Royces are the most expensive cars, and you know, it's my egotistical stroke and all that type of stuff. This car is priceless. It's Coca-Cola.
Oh my God,
It's
guys.
the real thing. It's the American classic. You
There's
know,
been
like
a verdict reached.
if you had to take all my cars, you could.
There's been a verdict reached. All right. Here we go. Hold on. Oh, already on screen. All right, guys, I need to write thank God I didn't stop my live. Okay. Let me write this tweet. Come watch with me. Come watch this verdict with me and my chat.
Okay, perfect. I appreciate it.
Okay. I have to give 2 streams. One. No, Coco, I can't handle you biting me and needing to jump all over me right this moment, baby kitten.
So you know more than I know probably, but the jury's ready.
Okay, share,
So process-wise is that
copy.
they'll bring them out. The verdict forms go to me also.
To paste horizontal stream. Okay. There we go. Sorry, guys. Let's pray. We have a verdict. Please remember to like, Lacey.
You just want to move that note while you're here. Just wait until the judge starts your good.
Okay. I almost jumped off of this stream.
Okay, go ahead and have a seat. So the court was informed the jury reached a verdict, is that correct?
Yes.
Thank you. So if you'll hand the verdict forms to the bailiff, he'll hand them to me so I can take a look at them. I looked at the form of the paper, essentially to see if they're properly signed. Well, that's the next thing that happens. Thank you.
I'm pretty nervous too, Peaches. Holy crap. This is the part, believe it or not, that I do not like about covering trials while they're happening. Thank you. I get so anxious. Let me put down my screen on the other. Thank God I had that going.
With regard to decorum, I don't expect any responses from anybody. It's been an emotional case. It's been a well-tried case. The lawyers did what they should do. The parties did what they should do.
I just want to remind everybody that how the verdict comes out isn't something of public comment. So if you have an emotional attachment to the verdict, don't express.
Shut the hell up.
Wait till you get out of the building before you let your emotions out.
Hi, Angel. Welcome. Please don't forget to hit the thumbs up button. Make sure you are subscribed and drop a comment. Help the algorithm, please.
So the verdict forms are properly executed, properly completed. Copies will be made available to the parties. In all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed. So the matter will be concluded with defense verdict. Thank you, Mr. Klingman. Thank you, Mr. Osborne. Thank you to the court staff and the Sheriff's Department for security in the building. And we'll go ahead and stand in adjournment. You're welcome.
God, I like. Yes, this is a great win for Turtle Boy as well. Holy smokes.
Relax, whatever it is you need.
I'll reach pose.
Yep. Have the jury go that way. Have them go back into their room.
You guys don't mind hang out in there for a little bit, I can get you, okay?
Do you guys think he's going to give an interview? Willa, you are not bad luck officially. We couldn't afford this. He would have survived, but it would have been straining on him, to put it lightly, and it would have been consequential for everyone. I don't want anyone's feelings to be hurt. I'm not like an awful person. I just want to follow the Constitution, for our civil liberties to be held up, and to live in a democracy where we can express ourselves. Because a lot of countries don't have what we have. That was quick.
That's what we're waiting for.
Hi, Deborah Jean. Glad you could join us. What happened? Yeah, this is quintessential Ohio, guys. I don't think this is my fault. You are so hard to find. Oh. Okay, let me
Literally, that's what we're waiting for.
Here we go. Let's see what people are saying. I do kind of, I'm not going to lie, I want it to be like over with. Let me see if anything else is feeling uh, buffering, because no, nothing else is buffering for me, guys. I think that the channel just got hit by like a million people. So if you guys are coming here to see the Afroman verdict, we just showed it. Please make sure to like this stream, sub up. It's free to subscribe to this channel, and drop an emoji or a comment in the chat. It helps significantly with the algorithm. I want to hear it again.
Warren, thank you to the in all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed. So the matter will be concluded with defense verdicts. Thank you, Mr. Klingler. Thank you, Mr. Osborne. Thank you to the court staff and the Sheriff's Department for security in the building.
He's looking right
And
at
we'll go ahead and
them.
stand in adjournment. You're welcome.
And good on him for following the rules and not celebrating and not caught. Why is he? That Rod or Ray guy is just staring him down. And I'm happy for the attorney that he got a win.
You guys want to go on into the jury room?
Yeah, judge was not happy.
I'll pitch vote.
Have to leave through to that, but have them go back into the room.
If you guys don't mind to hang out in there for a little bit, I can get you, okay?
Rhiannon. Hello.
Sir?
All right. That was quick, guys. We almost missed it. I think he's smiling. God bless America, guys. Thank you, Human Experience. I'm happy to have had you here. Yes. Thanks, Rihanna. Riri. I'm in Columbus, so I'm happy to have covered a case local to me. Last time I looked, it was only me and one other person live. I just had a feeling they weren't going to go home.
Everybody is excused. That's what we're waiting for. Literally, that's what we're waiting for.
Okay. And then the last thing I wanted to look at was to see if he's doing an interview outside. Go to their website and check. I'm going to the local station's website right now, guys. Watch now. Oh. Hold on. Pause. I found footage. Look at me. Hello? What happened?
Deputies in this case.
Not about freedom of speech. It's about defamation.
During closing arguments, the attorney representing the deputies didn't hold back his thoughts on Afroman's songs.
There's damage to reputation. There's pain and suffering. There's public humiliation. There's everything you saw and heard from these detectives from the witness stand.
This goes back to 2022, when plaintiff attorneys say Afroman, whose real name is Joseph Foreman, used security video from a raid on his home and put it in a music video, using deputies' likeness without permission. The deputies also say Afroman called them thieves and pedophiles, among other things, on social media.
He said it like they were facts.
Afroman's home was raided following warrants for possession and trafficking in drugs and kidnapping, though he was never charged. During the trial, deputies took to the stand, claiming Afroman's lyrics harmed their reputations and subjected them to death threats.
The tears, the agony from some of these witnesses, don't forget that when you're back in the jury room.
However, Afroman and his attorneys say it's his right to say what he wants.
Look at that suit. Does this look
Thank
like a man who thinks that everybody's going to assume that everything he's saying is fact?
Afroman claims the raid caused significant damage to his home and that deputies stole hundreds of dollars, though an outside investigation found that no money was taken, only miscounted.
It is a social commentary on the fact that they didn't do things correctly.
Afroman's attorney says the deputies are allowed to be criticized for how they do their job and are held to a higher standard.
The reality is a reasonable person in the eyes of the community is going to say, it's a song. It's a joke.
Now, when Afroman took the stand yesterday, he said deputies should have never raided his home in the first place. He said if they hadn't, there wouldn't be a lawsuit. Live in Adams County, Alex Knoll, WCPO 9 News.
Thank you, Alex. And now to this, a perfect regular season, but then a loss in the conference tournament. The Miami Redhawks still got selected to play in the NCAA tournament. And tonight,
Screw the Redhawks.
Sports anchor Caleb No live at
Sorry,
UB
guys.
Arena in
I went to
Dayton.
OU.
Caleb,
It's my alma mater's biggest rival. So screw the Redhawks. Okay. Excuse me. Wow. I am going to sleep well tonight. I don't know about you guys, but this has been real. This has been fun. This has been real fun. They should not have brought on this case. You are absolutely correct. If you could just, before you go, make sure to comment, even if you are watching on what's it called? Not live, but the term, if you were replay. And what's next, Lacey? I haven't until like tomorrow morning to figure that out. I have an idea. I was thinking about covering the Rittenhouse trial because I only do highlights here. So I don't watch a trial from beginning to end. But a few months ago, that was brought up to me that would be a good trial for me to show the highlights of. And then my other idea was to go through the top 5 over the next 2 days, the top 5 opening arguments and closing arguments. I thought that would be interesting. So I don't know of any other trials going on right now that I can jump into without confusing everyone. But once I get off of here, I promise you the first thing I do is check, get ready for tomorrow. This is a never-ending process. So I love that you guys found me, my YouTube or X people. And yes, please, if you are on the replay, please make sure to comment once I end the stream. People think I buy views because I don't get comments. I don't know why I don't get comments. I just don't. So I appreciate it. And I will see you guys tomorrow at 4 o'clock. Long live America. Long live our liberties and our freedom. We are very lucky to live in this incredible nation of ours. And I personally do not take it for granted. And this was a really good one, guys. Okay. Love you guys. I will see you tomorrow at 4 o'clock. Bye for now. Don't forget to like and comment. Yeah, I'm overwhelmed. Bye.